This trial is the matter of case number TCD 003-2022 and is being held before Justice Michael Black. Any orders or directions made during or after the course of this trial will be issued by the registry on the judge's instructions. Claimant is represented by Charles Russell Speechlys, LLP. Lead counsel, Mr. Glenn Bull. Defendant is represented by HLP law firm. Lead counsel is Mr. Badi Mokarzel. Would the judge and the counsels please confirm the situation is as I have stated?
That is correct.
Correct.
Mr. Bull.
Thank you, Your Honour. Your Honour, it's worth noting that we did not have a pre-trial review scheduled by the registry in this case. So if it pleases the court, I'd like to start with some admin matters that would otherwise might have been discussed during the pre-trial review.
Yes.
I understand that Your Honour is generally aware of the matters we wish to discuss before the commencement of the opening statements.
I think there are 4 roughly on there.
Correct,
You suggest firstly that this is a case which is suitable for immediate judgment, although I did note that you had made a previous application in that respect and it was dismissed by Justice Wayne Martin.
I can address that if you like, Your Honour.
Yes. Secondly, you have an application to strike out the witness statement of Mr. Kutapan, and thirdly, you have some observations on some of the other witness statements.
Correct, yes.
And then I think the defendant has an application to strike out the witness statement of Ms. Abbas. Is that correct?
That is correct, Your Honour.
So that's the agenda for the housekeeping.
Yes.
So do you want to deal first of all with the question of immediate judgment?
Yes, Your Honour, my learned friend sent an email on this topic Friday afternoon. I'm not sure if Your Honour has had the opportunity to review that email.
I've not seen that.
Right, I do have copies for the court if that would be helpful.
Yes, please.
I believe it is an example of the matters that I am concerned about.
Thank you. Give me a second to read it. Okay.
Your Honour has noted this matter was, the claimant did seek an immediate judgment order. Section D, document 1, page 865 of the bundle, there is a copy of the application for immediate judgment that was made by the claimant on the 13th of February 2023.
Yes, I've seen that.
The basis of this application is due to the fact that the defendant had not filed any admissible evidence at all in support of its case. The matter was held before Justice Martin on the 13th of April, wherein he agreed that no evidence had been filed and gave the defendant a period of 2 weeks to file its evidence. The orders that he made are at Section E, document 3, page 1035 of the bundle.
I've seen that, and I saw that he ordered costs against the defendants.
Correct.
In relation to that, which I found interesting on a failed application for immediate judgment, but I understand what you say, that it was on the basis that there was an absence of evidence and that effectively he he gave permission to file evidence.
They did file evidence. It was 80 days after the the claimant had filed its evidence. Now, at this moment, I just want to note that during the first hearing, Justice Martin explained to the defendant the fundamental question before the court in this case. He stated, now the issue presented on the pleadings was whether or not your client, the defendant, was entitled to the second progress payment, and that turns upon the question as to the extent of the work that had been completed at the time the demand for progress payment was made. The defendant has provided a very limited amount of evidence related to this issue, whilst it has explored other facts in some detail. It was thought that perhaps the defendant's skeleton arguments will reveal the relevance of this additional evidence and set forth a legal argument, but this did not occur. As such, the defendant has provided almost no evidence related to the key questions before this court in this case, but has also failed to make any legal arguments in relation to this question before the court. Defendant's skeleton arguments both open and close by stating that the basis for which the claimant's claim should be dismissed is simply that the court should allow justice to prevail. Your Honour, I invite the court to see this basis of legal argument essentially as an admission by the defendant's counsel that there is simply no basis under the contract or at law to support the defendant's defence or counterclaim. It is thus resorted to a reference to the court rules. I'm concerned that the cross-examination of the claimant's witnesses will not be focused on the relevant facts and questions before the court, and the defendant has the defendant has a misaligned expectation with regards to the process of this trial and the application of the law. Skeleton arguments that have been filed, it essentially looks as though the parties are arguing entirely separate proceedings. Perhaps this can be avoided, and we just use the time that we have today to assist the court with regards to the assessment of damages and costs. Alternatively, Your Honour, perhaps the court can provide some guidance on what the key questions of this trial are and what issues are irrelevant and out of bounds during the cross-examination. Such orders perhaps made pursuant to RDC 29.9. Provides, Your Honour, the court may control the evidence by giving directions as to the issues on which it requires evidence, the nature of the evidence which it requires to decide those issues, and the way in which the evidence is to be placed before the court. Your Honour, I can proceed with the matter of Mr. Kudapan, or perhaps...
No, let's deal with that first of all. Mr. Mukhariza, what is your response to that?
Okay. First, my name is Badia Mukarzel. I'm the lawyer of the defendant in this case. I'm just, Your Highness, want to stress on while all the matter according to client focused on one thing, major thing. Whether or no, the IF, the defendant, formed side progress works. Titled at that time yes, and we have client provided to the court enough overachieved the more than 30%. Not to talk about other discrepancies in Clement approach of the case and observing of the hasn't been terms of the close act. They didn't give us the grace period us or to remedy the cases, just notify us and kick off the defendant out of the project, while we were chasing Clement to meeting, to at least one meeting, on a progress meeting, and maybe a lot of mails to Mrs. Abbas, which was the expert appointed by the Clement, to get a meeting to discuss her report that has made factory, and they never came back on this issue. So this is a major point to us, knowing that a lot of the command and orders that we made for this project have been paid from our dependent own pocket and have been stuck in a warehouse in Dubai. Some of them, at least the loose furniture, shipped without any payment from the Clement, and have been stored in the warehouse, awaiting a kind of payment from the Clement to install it in the major arguments, which I want to.
I understand that, Mr. Mukarrazal, and I've read that. Mr. Bull, I'm satisfied that there are issues upon which I require evidence, and there are disputes of fact in this case. Of course, the primary dispute of fact is the extent to which the works were completed when invoice 63 was issued. I don't consider that this is a suitable case for immediate judgment. I'm going to have to hear the witnesses, so consequently the first application fails. So let's turn then to your application in relation to the evidence of Mr. Kutapan.
Thank you, Your Honour. As I've set out in the skeleton arguments, I respectfully submit that the evidence in chief of Mr. Kutapan is irrelevant and inadmissible. Mr. Kutapan should have prepared his evidence as an expert witness and not as a witness of fact. The factual merit and veracity of the materials he was provided by the defendant is unknown. As I stated in my skeleton arguments, the general rule of evidence for civil trials is that it is a function of the witness to give evidence of facts, and not for the court, and it is for the court, not the witness, to draw inferences and conclusions from those facts. Mr. Kutapan has in fact done the opposite of this. He has assessed unknown evidence and recorded his witness statement, and has recorded in his witness statement the inferences and conclusions that he reached during that process. I respectfully submit that the court ruled that the evidence in chief by Mr. Kutapan is inadmissible, and that Mr. Kutapan be excused from the cross-examination.
Thank you. Mr. Mukarrazal, what do you say about that?
I'm really surprised by the position adopted by my colleague, the Clement position, while all our evidence since the first application we made for immediate judgment and what was asked by the judge, that we provide a regular declaration or from Mr. Kutapan, which is advisory audit firm that we have appointed, and which he, in our opinion, and based on vote, exerted all his expertise in doing his job in this particular case, and I think very objective.
But the problem is that he didn't see the work, and that his evidence is just Well, I don't really understand what his evidence is. If he didn't see the work, how can he express any view as to its completeness?
I think he visited the site.
But he doesn't say that in
It's
relation.
obvious, Your Highness. How can he make his expertise if he doesn't have a fact analysis? I mean, you can ask him. I cannot talk on his behalf, but it seems for me that Mr. Hatapan, he contacted both parties, as you can check from his witness, and he went to Natasha in order to get a close midterm between the parties. So definitely he has a knowledge of the facts, and he visited the factories and the site as well. Otherwise, how can he do his approach?
Well, it's not very clear to me. Sorry,
I
if you'll allow me. I mean, it's not very clear to me how he gives evidence and how he assesses the valuation of the works, but maybe I have to hear his evidence to determine that.
If you allow me, Your Highness, I think Mr. Sagaya, he made a very detailed sheets on itemized sheets on the work site and outside the project, and I cannot understand how he can make this analysis if he cannot be present in place. I mean,
Well, I've seen the sheets in the trial bundle. All he seems to have done is produce the same figures as the defendant. I don't see any working out or analysis there, but maybe that's something that has to be dealt with in cross-examination.
I mean, what we provided to him has been validated by the audit firm, I guess.
But are you putting him forward as an independent expert?
Yes.
But his report, but he hasn't given the report as an independent expert. He hasn't complied with any of the rules.
Yeah, this question should be addressed to him maybe, but from our opinion, the IF engaged him, and he was paid for that, and he has another mission, is to enter into contact with the claimant representative, which he did, and try to align things between them. That's where he failed.
Well, I see that he can give evidence of fact as to what occurred in January. He was retained as a claims consultant on behalf of your client, not as an independent expert. I can't see how he can be independent and both a claims consultant. He can give evidence, certainly, in relation to his contact with Ms. Abbas in the January 2022 period, because, as you say before, it's part of your case that you were not given the proper opportunity for conciliation, effectively, before the termination agreement, before the termination notice. You'll have to take me to the relevant parts of the contract which provide for that in due course. So he can give evidence on that. On the other matters, I have some reservations, but since we're here at trial, Mr. Bull, I do think, particularly in the light of the comments that Justice Martin made, you may start 1-0 up in your cross-examination of Mr. Kutapan, but I don't think it's appropriate that I should just strike his evidence out. I should hear it and then come to a considered view, although I've indicated that I do have some reservations about it, but I don't have a closed mind, so we'll see what he has to say. Now, your observations on the other, I think, 3 witnesses who were the subcontractors or sub-suppliers,
2 of them were.
you say their evidence is not contentious. That's not a reason for striking it out. That's actually a reason for you accepting it.
Well, my point is that it doesn't touch on any of the works that were done on site.
But it's the other side's case. It's the other side's case that on a proper construction of the contract, the completion of the works includes works off-site. Now, they may be right, they may be wrong about that, but that evidence touches that. So how can I exclude it?
That is fine. It is just in terms of our understanding of this case, is that the contract is very clear, and please excuse me if I'm pushing forward too early, but the case in our skeleton arguments.
I know what your case is.
Yeah.
I've read. I know, and you say that the completion percentage has to be the completion of the works on site, not the off-site fabrication. I see that.
Okay.
So I think as far as your applications are concerned, I think that it is more appropriate that I hear all of the claimants' evidence for and consider whether it is persuasive or not. So all of the defendants' evidence and consider whether it's persuasive or not. I understand your submissions about Mr. Kutapan's position, whether he's an expert, whether he's a witness of fact. I will address that in due course, but I don't think it's appropriate to strike any of it out at this stage. Thank you very much. Mr. Mukazar, you have an application in relation to the evidence of Ms. Abbas. What would you like to tell me about that?
My application is made in reaction to the first application made by the claimant to dismiss a guy witness us matters as we based on the expertise of both parties.
Well, he hasn't succeeded in that application. Are you continuing? Are you continuing with yours or not?
No, in that case, we consider that Mrs. Abbas is a key.
I think she is very much a key witness.
This was a reaction, because if there is no witness, why Mrs. Abbas will stay the only horses on the round? I mean.
Yes, well, I'm looking forward to hearing Ms. Abbas's evidence. So I understand, therefore, that you withdraw the application to strike that out. Okay, well, thank you very much indeed. In which case, those are the housekeeping matters, and Mr. Bull, you can get on with opening the case.
Thank you, Your Honour. We are flying ahead of schedule. My concern is that Mr. Take is in Ireland, dialing in, so if we get too far ahead, it's going to be...
Well, then we'll just take a break, but okay. Let's proceed. So I think on the trial timetable, you suggested that each party will have an hour to open the case.
I suggested 45 minutes, I believe.
45 minutes.
I don't think it's too long. Perhaps I won't even go to that extent.
Well, let's see where. Yeah, I've got the timetable now. Let's see where we get to in terms of timing, and then Mr. Take is at 2:30. Perhaps one of your colleagues might just see whether he's available.
Yes, I did advise him that was possible, but I believe it's still 6:30 in Ireland right now. So
yes, yeah. Oh, quite yes. But we'll see how we get on, because 2:30 p.m. here would be 11:30 in Ireland. So if we were to start at 9 or 9:30, that would enable us to perhaps take his evidence at midday or shortly thereafter. But in any event, let's get on with the opening submissions and then take a break after that.
Your Honour, I'll start by briefly taking you back to the outset of the relationship between the two parties of this proceeding.
Yes.
As Your Honour will probably have noted from the witness statements, pleadings and the agreed background, the relationship between the claimant and the defendant had a rather unusual beginning. The claimant is the owner and operator of a cafe and restaurant premises situated in the Dubai Mall. The defendant is a fit-out contractor. About 11 months prior to the works, prior to the commencement of the works, the claimant approached the defendant with the idea of perhaps refurbishing the cafe part of the claimant's premises. Now, for background, the claimant's premises are designed so that to enter the restaurant, you have to pass through the left-hand side of the cafe. For the works period, this required hoarding to enclose the cafe, leaving a passage for patrons of the restaurant to pass through. It wasn't a perfect solution for the restaurant business, but acceptable as a temporary arrangement. In April 2021, the parties reached an agreement on the design and the cost of the refurbishment of the cafe. The 24th of April 2021, the defendant submitted to the claimant a letter with a bill of quantities attached to it. This document formed the contract. 28th of April 2021, the claimant paid the defendant an advance payment of 178,500 dirhams, which was 20% of the contract price. On the 9th of May, the contract was countersigned on behalf of the claimant and exchanged. From May to October, there was a long and unexpected delay as the parties awaited the landlord's consent to the works. Essentially, the parties simply handled this in stride. Works were mutually agreed to be suspended, the defendant pursued the consent, and the claimant provided assistance. In October of 2021, word had come from the landlord that it was about to grant its consent to the works. As such, the parties managed to ready themselves and during this period agreed a program for the performance of the works. A copy of this program is document 17, section B at page 247 of the bundle. The program assumed
Commencement. Look at that. Okay.
This document assumed a commencement date of 1 November 2021. The first step of the works was the installation of the hoarding. This effectively closed the cafe off from the public and created a clear and distinct site where the works were to take place. Pursuant to the agreed schedule, the hoarding would then be removed on 25 December 2021, essentially signalling the completion of the works. Allowing some wriggle room and minor delays, it was agreed that the works would be completed and handed over by no later than 31 December 2021. The date, Your Honour, was very critical, and this is an important point when it comes to the matter of damages that has been sought by the claimant. The claimant's restaurant premises opens up to perhaps the most spectacular view of Dubai, in Dubai of the Dubai Mall fountains, Burj Khalifa light show, and of course on New Year's Eve, the world-famous Burj Khalifa fireworks display. As such, the events planned for the claimant's premises on New Year's Eve were exclusive and spectacular. It was therefore a matter of real significance that guests that night would not pass through a hallway of temporary hoarding hiding an unfinished construction site. It was also the perfect opportunity to promote the newly refurbished cafe and for it to be seen by all patrons of the restaurant and the tens of thousands of people in Dubai Mall that night. Therefore, Your Honour, when the defendant agreed to this time frame, he was conscious of the importance of meeting that date. On 30 October 2021, the landlord granted its consent, and at 2 a.m. on the
What date was that again, please?
On the 30th of October 2021 is the date the landlord granted its consent.
Thank you.
At 2 a.m. on the 31st of October, the works commenced. However, to this event, I briefly note that the hoarding was installed by a third-party contractor who was engaged directly by the claimant. And actually, for that aspect of the works, the defendant was unable to get onto the site as it had not obtained the requisite security passes. In any case, The works were underway and a day ahead of schedule. This one-day head start was quickly relinquished by the defendant. The evidence of Mark Takei, at paragraph 45 of his witness statement, notes that by 10 November, the works were already noticeably behind schedule. Mark noted that there was no real active presence of tradesmen on site. In fact, as noted in his witness statement, Mark witnessed one night the defendant's tradesman arrive at the site at around midnight as he was closing the restaurant, only to be gone when he later returned at 2 a.m. that night. By the 17th of November, Mark Takei estimated the site works progress was about 10%. The furniture had been removed and most of the demolition was complete. The defendant had removed the water feature. However, the removal was defective as it had damaged the plumbing of the water feature. As a consequence, a foul drainage smell began to emanate from the kitchen area of the restaurant. 17th of November 2021, the defendant never performed any further works on the site. This, Your Honour, is an agreed fact. On the 30th of November 2021, almost 2 weeks later, the defendant submitted invoice 63, seeking payment of the first interim payment in the amount of 170,500 dirhams. Summary, the defendant had paid 20% of the contract price in advance back in May and was now claiming a further 20% of the contract price. Invoice 63 was a document, Invoice 63 was submitted with a document that was titled Progress Claim. In this document, the defendant claimed to have completed 54% of the works. Now, Your Honour, one can imagine the perspective of the claimant upon receiving this statement. He's walking past the site on a daily basis whilst he's operating the restaurant, and he hasn't seen a single ounce of progress for almost 2 weeks, and then receives a document claiming that 54% of the works had been done. The defendant had, for all intents and purposes, stopped the works. The claimant made efforts to try and intervene and encourage a resumption of the works. On this front, I will note that the claimant called multiple meetings, seeking to discuss the progress, and invited the defendant to provide progress plans on how it would finish the scope, hoping each time that it would continue with its proposals and promises. The claimant engaged an experienced project manager to manage the project and assess the works and clarify the defendant's requests for payment based on her experience and expertise. The claimant gave the contractor every opportunity to just crack on, carry out some works on site, and have an unassailable case for payment. From the 17th of November to the 28th of January, it never did. The defendant says it continued off-site works for this entire period, but how that could be possible remains entirely unclear. In any case, I reiterate that it is an undisputed fact that from the 17th of November, the defendant never returned to the site to carry out any further progress of the works. As a result, Your Honour, the claimant never paid invoice 63 and the defendant never resumed the works. The parties essentially dug in their heels and we had an old-fashioned stalemate. Now, I suspect it would be fair to say that both my learned friend and I have very strong-willed clients. They each took a stance that they believed in and they never backed down. The point to note, however, is that one of the parties took a stance that was lawful. His stance was supported by the terms of the contract. The other unlawfully committed a fundamental breach of the contract. Your Honour, I invite the court to find that it was the claimant who took the lawful stance. He was entitled to say no to the payment demand. He was entitled to stand his ground and pay the progress payment when the site works had progressed to the necessary level. I further submit to the court that it was the defendant whose conduct was intentional, reckless and unreasonable. Furthermore, a fundamental breach of the contract. Noted that the defendant's skeleton arguments speak of a breakdown in the relationship, of harsh conversations. It may have been the case that the defendant had personal complaints with the client's personnel, and that this led him to make irrational, unwise decisions with regards to this matter. He took a stand based on nothing on a personal justice, but one that was foolish under the contract. His conduct was intentional, and his conduct caused significant harm to the claimant. That harm was consequentially mitigated by the claimant proceeding to terminate the contract and have the works completed by another contractor. At this point, I'll ask Your Honour to turn to the contract, which begins at page 6 of section B of the bundle. Sorry, document 6 of section B, page 159 of the bundle. Parties are agreed that it was the intention of this contract to be governed by the DIFC law. This was a matter of preliminary debate, but has been agreed by the parties and is noted in the agreed background that we mutually prepared for the benefit of the court. Your Honour will note that the contract provides the following term in relation to payment of the first progress payment. It states 20% progress payment against site works progress, 31st of May. And was written by the defendant. My learned friend will undoubtedly seek to draw the court's attention to clause J of the BOQ, which states that timely payment is essential of the contract to ensure timely delivery of works completion. Payment delay beyond the scheduled dates as specified under the law of UAE, our commercial offer might affect the project payment timeline, which shall be demonstrated thereafter. Firstly, we will show that the payment of the first progress payment was never due. It was the primary position of the claimant that this term was irrelevant due to the facts. Noting the above...
It's agreed between the parties, isn't it, that the second progress payment became payable when the works had achieved 30% completion.
That is absolutely correct. I will just get down to that, Your Honour. Noting the above term, I submit to Your Honour that this case turns on a single question. Was the claimant ever obligated to pay the defendant the first progress payment? The answer to this question will determine whether or not the defendant was justified in taking the stance it did, stopping the works on site just 18 days after they commenced and never resuming them, or whether that conduct amounted to a fundamental non-performance of the contract. Consider this question, Your Honour. We have noted in our skeleton arguments that we have identified two factors that need to be considered by the court. At what point was the payment due under the contract, and was that payment ever reached? Or was that point ever reached? As noted a moment ago, the relevant term of the contract states 20% progress payment against site works progress 31st of May. This term admittedly includes a date that is fundamentally out of sync because of the initial delay period, doesn't define the progress required, doesn't define the site works progress. To the first point, there is a clear consensus that the date 31st of May was irrelevant. In fact, an invoice that was issued by the defendant around this date was retracted. Not a point of dispute in this case. This was an administrative error. I would submit to Your Honour that from the outset, the reference to 31st of May was nothing more than an indicative note.
Well, it's obvious, isn't it, that this letter and the date of the 31st of May was based upon the situation before the delay that occurred waiting for the landlord's consent.
Correct, absolutely correct.
And so the parties then agreed a commencement date in October.
Correct.
And that's common ground. So you have to move all of those dates, if you like, forward to October, don't you? and then recalculate the payment dates with a start date of the 1st of November or the 31st of October.
Correct. Even doing that, though, Your Honour, I would say that it still was indicative. That was perhaps the hope that the works had progressed sufficiently by that date, or the objective, but it was still necessary. The key trigger for payment was, in fact, the progress against the site works progress, and unrelated to the payment itself. Unrelated to that date that was noted.
Well, yes, that date was superseded, so...
Yes, but even if all of the dates were realigned to a start date of the 1st of November or 31st of October, the dates were indicative and just goals.
You say the governing words are against site work progress.
Absolutely. The second point, to the court that there was general consensus on the site that the trigger for payment was 30% site works progress. This has been confirmed in the witness statement of Mr. Fideli at paragraph 8. As such, this is also a critical point where there is no dispute between the parties. The third point, there appears to be real disagreement as to the intent and meaning of the words site works progress. In fact, at paragraph 3 of the defendant's skeleton arguments, the defendant's counsel has noted, quote, the parties are not aligned with the understanding of on-site and off-site work as agreed. This is the only point of dispute in relation to one of the most critical questions before the court. I will address it now. My apologies if some of what I say now is already set out in skeleton arguments of which you may be familiar, so please feel free to push me along if you like. Furthermore, if you have any questions on points that you wish to get further clarity on, I'd be more than happy to assist the court where I can. Your Honour, I submit that the word site has a clear and unambiguous meaning. In this case, the site was the OPSO Cafe. This was the part of the claimant's premises situated in the Dubai Mall, which was hoarded up. This was the area where the works were to be carried out and where the goods and materials were to be delivered and installed. Evidence of Mark Takei that the use of the term site works progress was understood by him to mean exactly that. The plain English layperson understanding, simply the progress of the works at the site. This was important to the claimant, as paying against the works completed on site provided comfort that the claimant would have a tangible benefit as the improvements were carried out on the site and the chattels were delivered. The value of the site increased and further payments would be made against the security of those works performed on the site. Except only for the advance payment, at no time would the claimant have expended more than 10% in advance of the real and actual progress achieved in his premises. It is clear from the evidence of the defendant's key witness, Mr. Sharif Fideli, that he was fully cognizant of the difference between site works and off-site works. At paragraph 34, Mr. Fideli's witness statement has noted, from the period of 1 November, we have not stopped working off-site or ordering material. Yes, the site works progress was not impressive, but due to the fact that majority of the works was off-site. Therefore, our position that when the defendant drafted the contract with the words site works progress, he had an obvious, the term had an obvious and indisputable meaning. This was simply the progress of the works on the site. The witness statement of Sharif Fideli and the defendant's skeleton arguments detail matters entirely irrelevant to the issue of site works progress. For example, the defendant seems to make a point that because he had expended the advance payment, he was now entitled to a progress payment. Because variations were being discussed, payment of invoice 63 was due. Because 53% of the total works had purportedly been affected, mostly of which it acknowledges was off-site, payment of invoice 63 was due. Another factor that is noted, is that Mr Fideli's witness statement seems to place relevance on the source of funds to be paid to the defendant's subcontractors. In paragraph 32 of Mr Fideli's witness statement, he recalls a conversation with Mark Takei whereby he noted that they could not pay the subcontractors until the defendant had paid the claimant. Quite frankly, Your Honour, all of this is entirely irrelevant. The simple fact here is that these arguments are unsupported by the contract. It may very well be the defendant's standard operating procedure to structure progress payments in a way that enables it to carry out projects with a positive cash flow. But the plain fact here is that it didn't do that in this case. The contract the defendant drafted did not do this for the defendant. For this, all that I can say is that this was a problem of the defendant's own making. It drafted the terms of the contract and it submitted them to the claimant for signing. Those terms aligned with the requirements of the claimant and were accepted by it. To the extent that the defendant may try to argue that the words site works progress can somehow be construed in favour of the defendant to include works done off-site is counter to the long-established principle of common law of contra preferentum. In situations of ambiguity, the words of the document are to be construed more strongly against the party who made the document and who now seeks to rely on it. This principle is explicitly enshrined in the DAFC contract law at section 54, where it states, if contract terms supplied by one party are unclear, an interpretation against that party is preferred. Summary to this first question. Before the court, I note the following. All parties clearly understood that the word site meant the OPSO Cafe. The term site works progress can only mean progress of the works on the site. The layperson or construction expert, there is no other way to construe this simple term. Off-site progress of the works was entirely irrelevant to the claimant's payment obligations under the contract. So too is the defendant's cash flow, the way the defendant used the advance payment, discussions about variations, or any other excuse raised by the defendant. The first progress payment was not due until the site progress equaled or surpassed 30%. Therefore, get to the next question. What was the progress of the works on site? The evidence of Mark Takei was that he estimated about 10% of the works had been done. Whilst Mr Takei is not a construction expert, this evidence is very strong because he assisted in the design and knew the project backwards. He walked past and looked in on the site every day. He could see the progress that was done. Each of the 18 days works were carried out on site and knew how much work had to be done to complete the project. Further to this assessment, the works were also assessed by the defendant, Natasha Abbas of N51, and Mr Kudapan of Good Faith Auditors, LLC, in a report that was attached to the defendant's defence and counterclaim. As noted earlier, on 29 November 2021, the defendant submitted invoice 63 with the progress payment claim document. This asserted that the defendant had completed 54% of the works with a cumulative value of 454,914 dirhams. The evidence in this case will show that the progress payment claim was entirely fraught with inaccuracies. Irrelevant with regards to the calculation of the site works progress, the document simply reported on the claimed overall progress of the works using methodology that was highly questionable. As an example of such inaccuracies, we can briefly look at three major BOQ items claimed by the defendant in that document. Of the 454,000 dirhams claimed, 88,900 was for joinery, 209,900 was for loose furniture.
You have to take the numbers more slowly.
Correct.
88,900 for joinery.
Would you like exact numbers? I can be...
Yes, please.
Yes. 88,907 and 50 fills.
Yeah.
The loose furniture was 209,922 dirhams and 50 fills.
Yeah.
For light fixtures, the amount claimed was 43,737 737 dirhams and 50 fils.
Going to omit the fills.
Okay, fine, that's... So in general, that's a total of 342,000 of the 454,000 claimed. 75% in effect.
Of the 400 and 455.
Don't right now have the exact figure of that, but it will be in a skeleton argument, I believe.
Okay.
In relation to these items, the joinery was being constructed by a third-party contractor at the party's premises. It was only ever partially constructed. The defendant had paid the subcontractor an advance payment for those works and done nothing more. In relation to the furniture and light fittings, the defendant had made an order for it with its supplier and paid the relevant advance payments requested by those suppliers. Nothing further was done. Plainly absurd to claim 100% of a BOQ item was complete by simply ordering that item and paying an advance payment. None of that takes into account title to the goods, delivery of the goods to the site free of defects, installation, cleaning, preparation for use. Next, we come to the assessment by Good Faith Auditors, LLC. On its filing...
Sorry, slow down a bit, please. Okay, carry on.
On filing its defence, the defendant attached a document prepared by Good Faith Auditors. This document is document 3 of section A, starting at page 22 of the bundle. It is understood that Mr. Sagaya Rajakudapan of Good Faith Auditors LLC carried out a desktop assessment of the defendant's works.
Yes, I have it.
Notably, this assessment determined that the value of the works executed at the site is 100,000 dirhams, 782. This sum includes the defendant's overheads and preliminaries, and in total equates to less than 12% of the value of the works. Your Honour, it is telling that an entity engaged by the defendant, who was paid by the defendant to prepare this report for the defendant, could only say that the progress of the works on site was 12%.
Well, 12% of the value, it doesn't say 12% of the programme.
Finally, the assessment carried out by Natasha Abbas of N51 Consulting. On 29 December 2021, Natasha Abbas carried out a detailed assessment of the site works progress. In doing so, she attended the site and physically inspected the works done and took note of the materials that had been delivered to the site. At assessment, she considered each and every item of the bill of quantities and the items claimed by the defendant in the progress payment claim. Carrying out the assessment, Natasha Abbas also took into account the fact that the works done by the defendant to remove the water feature were defective, and consequently deemed the demolition works to only be 10% complete. Consequence of this, and the fact that she deemed the hoarding works to have been outside of the defendant's scope, as they had been affected by a contractor engaged directly by the claimant, she determined that the site works progress was only 2%. Summary: the assessment done by the defendant considered the wrong question. It looked at total progress, not progress of the works on site. Again, its assessment of 54% total progress had been achieved is preposterous, and that will be clear by the end of this trial. The assessment of Ms. Abbas was strict and discounted works done by considering the cost of necessary rectification works. Fair to question whether such deductions were entirely warranted, but the unassailable fact is that the works that the site progress of the works was nowhere near 30%. Defendant's own advisor assessed the site progress of the works at 12%. Further aligns closely with the view of Mr. Takei, the person most familiar with the works and the project. Therefore, the submission of the claimant that the evidence that will be presented in this case will show with certainty that 30% of the site progress was never achieved, that payment and the first progress payment was never due, and the defendant's decision to abandon the site from 17 November 2021, just 18 days after it started and 12 days before it even submitted invoice 63, demanding the payment that stalled the entire project, amounted to a fundamental non-performance of the contract. Leads us to termination. Pursuant to the contract, the defendant was obligated to complete the works by no later than 31 December 2021. Program agreed by the parties prior to the commencement of the works showed a consistent progression of the works for a period of 58 days, where according to that program, the hoarding was to be removed from the site on the 25th of December 2021. It is the case, however, that the defendant had taken a stance that it would withhold performance of its obligations until the claimant paid the defendant the first...
So what page is the program?
The program is document 17 of section B at page 247 of the bundle.
Thank you. Sorry, do carry on.
Section 86(1) of the DIFC contract law provides as follows. A party may terminate the contract where the failure of the other party to perform an obligation under the contract amounts to fundamental non-performance. Section 77 of the DIFC contract law defines non-performance as a failure by a party to perform any one or more of its obligations under the contract, including defective or late performance. Section 86(2) of the DIFC contract law goes on to state, in determining whether a failure to perform an obligation amounts to fundamental non-performance, regard shall be had in particular to whether A, the non-performance substantially deprives the aggrieved party of what it was entitled to expect under the contract. B, I won't mention, I don't believe it's entirely relevant. C, the non-performance is intentional or reckless. D, the non-performance gives the aggrieved party reason to believe that it cannot rely on the other party's future performance. By the 28th of January 2022, it was plainly obvious that the defendant was not willing and or able to carry out its obligations. Therefore, invite the court, upon the presentation of the evidence in this trial, to find that the defendant's non-performance substantially deprived the claimant of what it was entitled to expect under the contract, and further, the conduct of the defendant was intentional and reckless. Further submit to the court that by 28 January 2022, when the progress of the works on site remained at 12% complete, the claimant had good reason to believe that it could not rely on the defendant's future performance. Time was up. The defendant had to be terminated, and the claimant had to mitigate the harm it had suffered and get the works done as quickly as possible. As such, on the 28th of January 2022, a notice was served that terminated the contract. Section 109 of the contract law provides that any non-performance gives the aggrieved party a right to damages, either exclusively or in conjunction with any other remedies, except where the non-performance is excused under the law. The claimant submits that the contract law does not excuse the defendant's non-performance. Section 110 of the contract law further provides that the aggrieved party is entitled to full compensation for harm sustained as a result of the non-performance. Such harm includes both any loss which it suffered and any gain of which it was deprived, taking into account any gain to the aggrieved party resulting from its avoidance of the cost or harm. I will not endeavour now to detail the harm caused in this opening submission, but have set out the relevant calculations in our skeleton arguments.
Yeah, I have an issue about damages. Would you go to page 159, back to the contract, please?
Section A document.
Just put in page 159. I haven't got the...
Oh, sorry, there is a search here. Correct.
Okay. Now, what about the penultimate paragraph here? In case there is delayed in the performance of the works, we shall be liable for paying an amount of 5,000 dirhams late payment fee for each day of delay from the date of handover, 15th July. So, substituting the date for the 31st of December because of the delay in the commencement, there's an agreement for liquidated damages for delay. I think the works were eventually completed, albeit by another contractor, on the 23rd of March of 2022, from recollection, which I also think is some 82 days after the 31st of December. So my question for you is, and I know you're going to want to claim the higher amount because it's slightly less than your damages, but isn't this an agreement for liquidated damages which may or may not survive the termination?
I think that's the question. Our position is that it doesn't survive the termination.
Well, you're going to have to address me on that. That's why.
Understood. Don't have the materials with me now to address.
Well, you're going to address it in closing.
Very good. We'll absolutely make a point of that in closing.
But if my arithmetic is correct, then if you're entitled to liquidated damages, it would be 410,000 dirhams. I think I'll tell you the difference to yes. So 410,000 as against 548,108. So the total claim would then be 893,620 if you succeeded, and if I were minded to find that that was a liquidated damages clause.
Thank you, Your Honour.
But I should like to be addressed upon that.
Very good. Your Honour, I don't have much further to say. The defendant has failed to address the question in its skeleton arguments. We've already touched on this earlier this morning. But I note that it's hinged its case on the argument that the court should allow justice to prevail. The defendant both opens and closes its skeleton arguments on this point at paragraph 4, introduction, and its final paragraph of the document. Your Honour, I invite the court to see this argument as nothing less than a surrender. The defendant has in effect conceded that it cannot win this case by the proper interpretation of the contract and the application of the law. I believe that the defendant's general manager, claimant stood by the contract it was entitled to. The defendant has made no argument that it wasn't. It only seems to say that Mr. Fadali feels that enforcement of the contract pursuant to its terms would be unjust. As such, and that I've already touched on this. I must say that I did not think to include in my skeleton arguments that the claimant seeks justice, but for the avoidance of doubt, the claimant seeks justice. Of course, Your Honour, justice will flow from the proper interpretation of the contract and application of the law.
Thank you very much. Mr. Mukarzell, we'll take a short break now. Let's break until 25 past 11. I have 11:12 now. Okay? Right, 25 past.
All rise.
So,
Honor, as defendant statement, we will emphasize on the following. As recalled, April 24, 2021, the claimant and the defendant Fashion Avenue, Dubai Mall. The express terms of the contract were recorded and signed by the claimant. The fundamental obligations, therefore, of the parties were set out on the third page, which are as follows. 1. The defendant shall not be responsible for any delay caused due to or from any agencies working on the permit.
Where do I see that?
This is the obligations by contract law.
Yes, where do I find those?
Check it on the contract.
I found it. It's page 161. That's a E, isn't it?
E,
Yes.
the IF, yeah, shall not be responsible, exactly. The assumptions and exclusions.
Yes.
Okay, so 1, the defendant shall not be responsible for any delay caused due to from any agencies working on the permit. 2nd, timely payment is essential of the contract, and we emphasize on this term, to ensure timely delivery of works completion. Payment delay beyond the scheduled dates as per the applicable law, which may affect the project timeline, which shall be demonstrated. Based on that, we emphasize that on May 2021, the parties expressly agreed to commence work upon receiving the advance payment. However, the claimant, for reasons of his own, did not receive the necessary approvals and permits from Amar. Thereafter, the works were suspended in July 2021. Meanwhile, the defendant has procured the furniture and other materials and stored them on site. Are very clear on that. After obtaining the approval from Amar, the defendant informed the claimant that they need 60 days from the date of approval by Amar on the mobilization to complete the scope of work, and anticipated the completion date of December 30th. Defendant completed more than 50% of the scope of work by end November 2021 and submitted respective invoices to the claimant. But the claimant never released the payment despite various meetings that took place between the claimant and the defendant regarding the progress of work and payment of the invoices. The claimant is fully aware delaying the payment would badly affect the progress of work. However, has persistently delayed the payment evaluation by the project management consultant assigned by the claimant, thereby insistently failing to issue payments. I would refer also that, and in summary, just to give some figures, the claim of the payment was 180,710 AED to cover the loose furniture and the custom-made joinery items in the factory, which have been covered by the IF. RG, I mean the claimant, had initially agreed to a new payment term not related to the site progress, but based on the overall works done followed by the below course of events. And I will refer to the email of Mark from the claimant, whereby he agreed.
Sorry, what email is this?
Page.
You give me the page in the top right-hand corner.
818.
818. Sorry, that's not an email at 818.
Oh, item, I think, paragraph 27. But it mentioned.
Yes, this is.
In October 24 to 21, we have received a mail. This is a statement of Fadali from Mark amending the agreed payment terms of the quotation into the following. So 20% will be released this week for all works to commence if hoarding goes up 30th of October, which has been done, obviously. Next 20% released will be after 60%, so and so. So it's important to mention, Your Honor, that the meetings with Mark have consistently changed the schedule of payment, and it was obvious that.
So you're saying on the 24th of October, there was a variation of the contract. Is that your case?
This is an email received from Mark.
Well, we ought to have a look at the email. Where do we see that? I will have to decide whether or not the contract was varied in some way, whether they agreed.
In order not to delay a lot, Your Honor, can we submit later the email?
Yes, of course. Just so that I know. So you are saying there was an actual agreement on the 24th of October. That's your case, yes?
I mean, there was an agreement of rescheduling the payment, at least.
Yes, that's what I mean.
Yeah,
To vary the contract, to reschedule the payments.
Because the idea, Your Honor, is this project was delayed from the beginning due to the clement relation or to the clement negotiation with Amar. So at first place, the defendant couldn't be blamed if there is such a delay, which occurred from April till July.
Yes, I don't think anybody's saying that.
No, we were blamed on something that we were not involved to. However, the advance payment was made, I agree, and the defendant made necessary order and started to work accordingly off-site. That was obvious from the defendant's side. Anyway, what the idea is to explain to the court that this works is not arithmetic or something like we are chasing you on a 1%, 2% per day of work in progress. The idea is to what extent the defendant is involved in this project on site, definitely on site, because what you mean by on site progress? If I ordered the furniture from the grease factory and DIF involved personally to ship this furniture without getting the payment from the claimant because of the relationship with the factory, and it has been shipped without getting any penny, and this shipment have been stored in Dubai, awaiting that the claimant execute the second payment or the 20% payment, and which he did not. And that was the purpose of the meetings with Marx on site. And Marx agreed that, okay, we will give you an advance on the second payment, and then we will release at least the loose furniture, and it will be installed in the cafe, which have never been done or completed. Anyway, this was the idea of what we consider relationship cooperation between the two parties, and which was abruptly suspended by the claimant. So again, the defendant completed more than 50% of the scope of works by end November 2021 and submitted the respective invoices, but the claimant never released the payment despite various meetings that took place between the claimant and the defendant regarding the progress of work and payment of the invoices. Claimant is fully aware delaying the payment would badly affect the progress of work. However, it has persistently delayed the payment evaluation by the project management consultant assigned by him, by the claimant, thereby insistently failing to issue or settle payments. On January 26, 2022, the claimant abruptly sent a termination letter to the defendant, leaving the defendant high and low of all the expenses incurred by them thus far. The defendant replied to the termination letter by requesting the claimant to take responsibility for the termination and settle the outstanding invoices, but this went too unheard. The defendant rejects the claim amount and considers the claim as mere false allegation, which must be rebutted in their entirety. Further, it is an implied term of the contract that the claimant should have honored its obligation, the implied payment obligation of the contract. One.
Sorry, what do you say the implied term is?
What is meant to be the obligation? I mean.
What do you say is the implied term of the contract?
I mean, what is understood between parties? It's implied. It's
yeah, but what precise term do you say is implied here?
A reference you mean?
No. You said it's an implied term of the contract. So what is the implied term of the contract?
That the payment will be released immediately after the work's completion of...
Well, that's next. Sorry, there is an express term for payment in stages, progress payments. It's agreed, I think.
Likely, yeah.
It's agreed that that after the initial payment, the second payment, I think you agree, is at 30% completion. Do you agree with that or not?
Yes, Your Honor.
Yeah.
Right.
So that's the express term of the contract. But what is the implied term that you're talking about?
The implied term is what is in the DIFC contract of law. What should be meant that there is an obligation implied, which is not the express one mentioned in the agreement. I mean,
Yes.
It's the idea.
Yes. Well, we know what the express payment terms are.
No, it's not integrated in the contract as such. But I mean, it's implied that whenever the party or the defendant accomplish the 30%, it should be honored immediately.
Okay.
That's the idea.
So it's implied that when they reach, I just want to make sure I've got it down right. When the defendant reaches 30%, that will be paid the next stage payment. Yeah.
To the Article 57 of the IFC law,
Yes.
the contract law, A, having arisen from the nature and purpose of the contract, it was implied in obligation under, and having arisen from the good faith and fair dealing, it was an implied obligation under Article 57C of the IFC contract law. Reasonableness, Article 57D, which is reasonable, I mean, interpretation of the agreement. However, we strictly reached, and as we said, expressly reached 30%. It should be implying also that the parties should then on a good faith, on a reasonable manner, and a proper and natural purpose of the contract. And to give a business efficacy to the contract as well. Summarizing this matter disputed, we point out on the following. One, the claimant does not consider loose furniture and joinery as part of site work in progress, while this has been clearly stated in the contract and quotation agreed by the parties, that loose furniture and joinery will be part of the project overall. This effect, our client, Sharif Fadali, would like to demonstrate in his witness statement and the witness appearing the scope of work in addition to the actual execution of work under the project. Second, one of the witness statements submitted by the claimant, in particular Mrs. Natasha Abbas, was not completely informed of the change in design, nor did she visit the factor, at least the AMG factor, to examine and evaluate the work in progress. Therefore, based on what facts that the witness statement being drafted? The big question mark.
Sorry, you say she did not visit?
She did not visit AMG factory. She went only to the loose furniture at 360.
Okay.
And she did not communicate her report in order to discuss it before submitting, which is ethically could be the case. We never seen the report of Mrs. Abbas to discuss it, or at least to, in a good faith, to try to remedy, knowing that, and this I have to mention to your honor, that after the termination, as you know, they appointed a new contractor, and immediately they paid the loose factory, and they released the furniture as if we were pushed to leave the project on personal level. We don't know why. She is asking for documentation regarding the loose furniture, which we were providing on the way to providing to her, but we were terminated abruptly, and immediately after termination, the claimant engaged the same factory to deliver the furniture and paid them. So we don't understand why this amount wasn't released on time to the defendant, and we could avoid all this dispute and we could finish the work in time.
I think the claimant would say because the work on site hadn't been done since the 17th of November.
Yeah, but this is chicken before the egg.
Well,
chicken. If we are not paid, if the defendant is not paid, while he considers that 30% is achieved, and we had a meeting, a comprehensive meeting.
No, but we're talking about the 17th of November, which is before the 30th.
Okay, But
So your client, it's an agreed fact that your client stopped work on the 17th of November.
at that date, my client considered that the work of 30% have been achieved, asking for the payment.
No, well, you didn't ask for another 13 days.
We did. When was the claim from Philip?
The 30th, was the 30th.
Dilip, when Dilip
Was it the 28th or the 30th of November? I can't remember, but he stopped work on the 17th. I'm just wondering why they stopped work on the 17th. If you,
This is a Clement, allegation, I guess.
no, it's an agreed fact.
Let me check.
If we go to, I think, where is it? Let's have a look. Jointly agreed background. Item 20 at page 1809, page 4 of 5 of the agreed background. From 17th November, DIF did not carry out any further works on site. And then the invoice was submitted just under 2 weeks later, on the 30th November. So I was just wondering why the respondent stopped work on the 17th of November.
My answer in my understanding, Your Honor, work has been completed over 30% on October. So way before, on October 24, according to the meeting with Mark. So it is well known in this meeting, so I refer to the same page.
So you say
818.
yes.
Whereby it is stated here in Fadali's witness statement, paragraph 27.
Let me go back to it,
Yes.
page 818. So you're saying it's your case that actually 30% of the work had been done by the 24th?
Way before November 27, yeah.
On the 20th, so when do you say 30% was completed?
No, if we refer to the paragraph 27 on this particular page, 818, so it said in October 24, 2021, we have received mail from Mark, the one we will provide later.
Yeah, it would
amending the agreed payment terms of the quotation of the following.
But that doesn't help
20%,
me.
yes.
That doesn't help me as to when 30% was completed. And we're going to have
because
a look.
they fix it to the hoarding works that goes up to 30th of October. There was an indication particular works to be achieved by October 30th.
So if the contract was amended whereby the payment was due on the 30th of October, why was the invoice issued on the 30th of November? Why did, if cash flow was so important, why wait another month?
Why we issued the invoice on November?
Yes.
Because they never respect this email. This email was not honored by their side.
But you didn't even issue.
They changed their mind.
Didn't even issue an invoice.
No, at that time because they changed their mind.
Well, I'm going to have to hear the evidence on this. It would be good to see the email.
Yes.
See if we can find it.
Again, Your Honor, if we stick to the original agreement, then the invoices was issued on November 2027, and this was corroborated by the report and the statement of Tagaya. It was clear for him that the defendant that time has achieved more than 39%.
So what do
His
you
witness statement.
what do you want to show me now?
Sagaya's witness statement.
So that Mr. Kutapan, yes.
Yeah, Itapan.
Okay, and where do you want to go?
If we go to his detailed sheet,
What page is that?
go to Sagaya's statement. Seven 711.
711, thank you. Okay, and what do you want to show me there?
So Sagaya, Mr. Sagaya, he ended up in his evaluation and assessment of work.
I'm on page 711.
Yes. 39% achievement assessment made by Sagaya while he has reviewed the defendant assessment.
And what date is this?
That's in the 711.
Yes, I know, but what date?
At the end of the sheet, if you go to the total, the progress percentage.
I can see that.
Yes, and he made the assessment in paragraph 32. As I assessed that the progress was more than 30%, which is the percentage that entitles defendant to request the first progress payment.
So I'm getting slightly,
Yes.
I'm getting slightly confused because a moment ago you told me that in October your client had achieved more than 30%. That's what you said in October.
No. Said that in October they had a meeting, a progress meeting with Mark, that an email received from him accordingly,
which we haven't yet
the
seen.
payment, and that they commit to release the second payment of the 20% as far as the hoarding is achieved by October 30th. This is the 3rd of the May.
Okay, so you're
You're
not saying that they had achieved 30% completion in October? No. Okay. So let me just.
I cannot ascertain, and maybe they achieved, but I cannot. Me as in my position now, I cannot ascertain. Maybe they did it before, but I cannot ascertain. It needs a specialist to do that. But I'm sure that on November 27, this have been exceedingly achieved.
Okay.
So, and I refer to the statement of Mr. Sagaya.
Yes.
That where he said in paragraph 32, as I said, that the progress was more than 30%, which is the percentage that entitles the defendant to request the first progress payment. I have assured myself that defendant has made a valid payment request and supported defendant.
Okay. And we'll hear from him his evidence as to
Yes.
what he did to make this assessment. Yes.
So back to the summary. So I do raise a question mark, as I said to your honor, regarding Natasha Abbas' statement, knowing that we haven't been communicated on time the report that she submitted to the chairman and against defendant valid claim. And second, Mrs. Abbas did not visit the factory of AMG, which is a key work in progress in the project.
Just two questions, if I may. Did Mr. Kutapan produce a report?
Did Mr. Sagaya?
Yes.
Yes.
And when was that given to the claimant?
A report?
Yes.
No, this was after the termination, I guess.
Yes.
Somewhere in January 2022.
But you see, you're criticizing Ms. Abbas for not providing a report when she did her assessment. And I'm just wondering when Mr. Abbas did his assessment and whether his report was provided to the.
Abbas should be on
No. Let's just focus on Mr. Kutapan.
Sagaya.
Yes. We have a saying in English, which is the pot calling the kettle black. So I'm just wondering whether you're criticizing Ms. Abbas for the same thing that Mr. Kutapan did or didn't do.
No, because Mr. Sagaya, he did enter into communication with the claimant.
But did he ever produce the report?
I don't know.
Okay.
I have to ask.
And the other thing, the other criticism you make,
but which I'm
the other
sure of that Mrs. Abbas did not communicate the report.
Yes, and the other thing you criticize Ms. Abbas for not visiting the subcontractors. Did Mr. Kutapan visit the subcontractors?
He produced at least. I guess he visited, but cannot commit anyway. You have to ask him.
Yes. Okay. Thank you.
The report was produced by Mr. Sagaya on February 21, 2022.
Okay, thank you.
So, resume my summary. So the parties could have avoided a dispute by allowing a termination clause to trigger for a previously agreed upon reason. Therefore, there was no act conducted to mitigate the dispute by the claimant. This was really a bit sad from the claimant at that time, according to my client, that besides all the effort to reach out an agreement, because the deal could have been saved easily. I mean, this is a question of a couple of small payments that already the defendant has advanced half of it to the factory and to the lease furniture. But for a reason we don't know why no meeting has been held, effective meeting, if not at all, to remedy about this abrupt termination, which is due by the contract. So they never trigger or initiate any meeting if this contract could be saved or solved in a way or another. So this is important to point it out to your honor. Finally, so for us, the disputed points again are a gap in the understanding on-site work, witness statement drafted without full knowledge and personal presence, alongside the significant cost that impacted our client due to unilateral, abrupt, and unlawful termination. Yes, Your Honor.
Those are your submissions, are they? Yes, thank you. You said something this morning when you were just responding to Mr. Bull's application for immediate judgment that I just wanted to follow up on to make sure I understood your case. You said that they hadn't followed the procedure for terminating the contract. Could you just explain to me what you meant by that?
They served the notice to the defendant. This should, by law or by contract, should be followed by what we call it an escalating meeting between the parties in order to remedy or not on the default if such default is evidenced by the parties. Such meeting did not take place.
Okay,
and I think this is an obligation. It's not a question of.
And what is and where do I find that obligation?
What was our obligation?
No, you said there was an obligation to have a meeting. So I understand that sort of dispute resolution mechanism. Where do I find it in this contract?
I think it's part of one of the exhibition. It's in the quotation, in fact.
Yes.
Yeah, maybe I cannot find it out as a mere terms, but in the quotation, and dispute arising out in connection with this contract, any question regarding whether the tenant shall be subject to the court of file, this contract shall be governed. No, what I meant by that definitely, a meeting should have occurred after such a termination, specifically that the defendant was pushing for such meetings way before the termination was served, and nobody was reacting in the side of the claimant. So our understanding, Your Honor, is that the termination of this contract has been made on no reason, no legal reason, no ground, specifically, and the defendant has achieved more than the requested percentage of the site in progress, according to the state. And this issue, which is the major disputed item, has never been discussed between the parties on site. We have been ejected like if we did not have any concern about this project, which is not the truth. And specifically, once ejected, everything went in a proper way suddenly. The money have been paid to the new contractor. The money have been paid to the loose furniture without any documentation or without scrutinizing on all this stuff, as if there is an intention on purpose that my client be put out of this project. This is what we have to say. It's up to Your Honor to identify whether or no this project has been properly conducted by the defendant, which we consider that it has been more than requested from our side.
Thank you. So, Mr. Bull, do we know anything about the availability of Mr. Take?
Yes, I have been in contact with Mr. Take via text message. He has asked that he would need until 1:30 Dubai time to be...
I was going to suggest that.
Yes, okay, well that works well. I thought it was lining up perfectly. Ms. Abbas, originally she was scheduled to come on quite late because we did believe this would be...
Yes.
We thought Your Honour would be based in London, and so our timetable was a little bit out to begin with. She has advised me that she wouldn't be available at 2, but if we push mark to 1:30, then I suspect Natasha will be somewhere around 3:30. I have to liaise with her to find out what her best time is, but...
Well, if she can make it... we've got Mr. Take for an hour at the moment, which would take it to 2:30. If she can be available at 2:30, that will be great.
I'll pass that on to her, yeah.
Yes. Good. Well, in that case, we've come to a bit of a halt, and we're going to have to adjourn now until 1:30 in that case. Thank you very much.
Please.
Good afternoon, and hello, Mr. Take.
Good morning, John. How are you? Nice to meet you.
I think I'm getting some feedback. I know what I need to do. Yeah, that's it. My feedback's gone. Thank you. Right, Mr. Bull, would you like to introduce your witness? It's got to be sworn, first of all. Then you can introduce your witness and put his evidence on the record. Now, would you swear?
Mr. Mark, can you please provide us with your full name and occupation for the record?
Yes, my name is Mark Gabriel Take, and I was working as a Director of Operations for RAFID Gourmet.
Thank you. I understand today that you wish to affirm rather than swear, so please repeat after me. I solemnly swear and affirm
I solemnly swear and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Your Honour, I call Mark Gabriel Take as a witness. Mark, hi, thank you for joining us today.
Good morning.
On the 6th of February 2023, you signed a witness statement. I have this, I'm not sure if there's a camera, if I can show where he has signed this document.
Doesn't he have access to the documents?
Mark, you have a copy of the witness statement with you today?
Yeah, Glenn, I have access to it there, yeah. It's on my screen.
Okay, yeah, so on page 113 of that document, the red number on the top right-hand corner, which is page 15 of your witness statement, you have signed this document under a statement of truth, declaring that the statements made in this witness statement are true and correct, and you understand, and that you understand the proceedings for contempt of court may be brought against anyone who makes a false statement in a document verified by a statement of truth. So is this your witness? Is this your signature on page 15 of your witness statement?
Correct, Glenn, yeah.
Thank you. And Mark, have you had a chance to review this witness statement recently, considering that it was written in February of 2023?
Yes.
And is there anything that you would like to amend or change with regards to the statements made in this document?
No, Glenn, it's same as what we had discussed and what happened, you know.
Perfect, thank you. Your Honour, I tender the witness statement of Mark Take as evidence in this trial. Thank you. And I hand over to my learned friend.
Yes. Carousel.
Allow me, Your Honor. This is the email we refer to. Fine. Regarding the schedule of find out, it's not in the bundle, it's part of his witness statement.
This is not in the witness. This is not in the bundle at all.
It's not in the bundle. It's part of the witness statement of Sharif. And 188, I guess.
And perhaps we deal with this shortly after the after Mark has spoken.
Yes. Okay. Mr. Carousel, witness is yours to cross-examine.
Okay, I've read your statement, and I have two simple questions to you.
Yes.
Is during the contract duration, do you have any major claim against the work in progress from the side of DIF or from the defendant? And if yes, what could be this? Because in your statement, you said that there is some.
I think it's easier if you break the question down into individual parts. Otherwise, the witness is going to have difficulty answering it. So take it a step at a time. Okay.
So, my question to you, did you hold a meeting with my client on October or during the work in progress, and where some discrepancies started to rise between both parties, and whereby during this meeting you have agreed to reschedule the works and the payment accordingly? I'm referring to your meeting and your email that you sent accordingly to Mr. Fadali on October 24th. Is that happened?
So can
and
I?
My second question.
Sorry.
Mr. Mukhauser, first of all, one question at a time.
This is the question.
Secondly, no, there are about 4 parts to that question. Secondly, you can't ask a witness about a document without it being in front of him.
Before this, I'll finalize.
So you have to don't interrupt me when I'm speaking. You have to show him the email that you're asking him about.
Can I show it to him? Let me formulate it another way, Your Honor. Okay. Mr. Mark.
Yes.
Did the DIF finalize the work on site on November 27 regarding the board's work, yes or no?
Sorry, regarding the what work? Sorry.
The boarding works, because
sorry,
there
George,
is a reference to
may
the
I talk,
boarding.
please? May I talk? May I talk? It's okay. Can I speak?
Yes, go ahead.
Yeah, I mean, to be honest, I think that we're jumping a little bit ahead here on initially the problems that we had before the date that you've given in relation to the hoardings. You know, as you can see from my statement and from me personally, there was numerous emails back and forward because the work on site was not actually done as per the agreement that we had made and the percentage for payments to be released. Now, I personally went back and forward with the guys from DIF to have them come in to schedule meetings with us. Unfortunately, we didn't get the reaction that we were expecting from them. And then I believe down the line, I believe the project was handed to someone else because the 2 guys we were dealing with were no longer with the company. This, in relation to the hoarding specifically, I want to be specific on this. One of the gentlemen, Mohammed, basically he was the guy that we sat with when it came to all MEP drawings and stuff like this. Now, what I believe happened was within the time frame of the project being handed over, Mohammed was no longer with the company, and from what I recollect, that the part of the hoarding was damaged from when the guys started to demolish the area. But again, I think we're jumping a little bit too soon because there was many problems and meetings and email correspondence months before this issue. So I hope that answers your question.
Okay, so yes, thank you, Mr. Mark. But technically, when you say there was no achievement from the DIF on the ground, what do you mean by no achievement? These people were not involved on daily basis on the works, yes or no?
So initially, when the project started, we had one gentleman on site who started on the project, but it came after 2 to 3 weeks. It became, and based on the work plan that they had given, although it was very difficult to understand, they hadn't achieved what should have been done. The work was not completed on site, which led to a number of meetings and me actually visiting off-site also to check works that had been done off-site, which also were not ready.
Okay. Answer question. When you said the work was not completed on site, you mean the percentage of work that should reach a certain percentage of 30%, you mean
Correct.
was not completed? And to your understanding, what was the percentage that have been done on site?
I mean, to be honest, I think we had agreed they maybe had 15 to 20% of the work done. The main work that was done, that they were trying to clear the site. You know, there wasn't a substantial amount of work that was done on site at that time. Although they started on demolishing some of the stuff, but a lot of the debris and stuff was still left on site. So yeah, the percentage of work, it was agreed that they were not close to that.
So in other terms, that was a problem of demolition that haven't been removed in order to get the things fixed on site. That's part of your statement?
Well, I mean, no, I mean, to be honest, I would have assumed logically, you know, obviously and again, not the first project that I've worked on, but normally when the demolishing takes place, it's cleared off site so that the guys can actually start work. This wasn't the case, you know, and also with that, I mean, they had started on some electrical works and stuff like that, but none of it had been finished.
So you mean the MEP wasn't finished at that time, or wasn't initiated?
It wasn't finished.
But they start working on it, right? So the MEP was started to be installed in the place.
I mean, they started putting holes in the walls and stuff like that to run cabling and stuff, but it wasn't complete.
So in your understanding, all the works that have been done at the time where my client was asking for the second payment shouldn't reach 20% of the work?
No, it was not. No, it certainly was not. No. And the issue we had, sorry, just to interrupt you, the issue we had, the guys kept insisting that the work was done, plus the work that was done off site. Now, I actually went and I visited twice the factory that was used off site, and the work was not done. The items were being produced in an open area. The cabinetry was not anywhere near ready to assemble for the retail shelving that we had. So yeah, it was very, very worrying at this particular time, which led to us then having to bring in our consultant Natasha, because we could not get any further with the managers. So at that we then decided to bring in a consultant from North 51 Consulting, Miss Natasha.
Okay. As far as you are concerned, did you meet with the consultants that the client, my client, that DIF engaged on the place to assess the works? I mean, with Mr. Sagaya?
Mr. Sagaya, I don't recall who this gentleman is. I don't recall meeting with him. We did have a number of, we actually requested a number of meetings, which were quite difficult because some of the guys were in the country, some of the guys were not in the country. Eventually, we had a meeting with one of the senior project managers. I do apologize, I don't recall his name. But that meeting broke down quite quickly because we tried to do a walk around with them and say, look, this work has not been completed. This is still not finished. We had also arranged then, I think, at that point to go and visit to see what was being done offsite, which again was nowhere near close to completion for the dates that we had agreed on.
Yes. So if you met with his officer or gentleman or an expert from the good faith, so because according they tried many times to reach out of the Clement people and to set a joint meeting in order to assess and to bridge the break between both of you. And according to them, works have been largely accomplished inside the shop.
I mean, again, sorry, but I think we need to go back to specifics here, because we had numerous meetings, we had numerous requests, we had numerous phone calls to set up a meeting to try and find a way out of the issue that we had, because you know, at points the communication broke down. I couldn't get through to SM, I couldn't get through to the senior guys within the company. You know, we had requested on numerous occasions meetings with the guys because the work was not done. I believe we had sent emails with pictures. You know, so again, in regards to a specific meeting, I can't recall, but what I can say is that we requested numerous meetings with the guys, which, you know, it was very, very difficult. And I think the reason being it was very difficult because the two main gentlemen who took the project, I don't think were any longer with the company. This caused a massive delay in everything, to be honest with you, because it didn't seem to me that these gentlemen were given a proper handover. So, you know, initially when we had requested meetings, it took some time for them to get back to us. When they came to the meeting, they were not prepared. And again, the two gentlemen who initially were project managing, one which was on site, which I believe I think his name was Yogesh, and the other gentleman's name was Mohammed. Now again, I don't know internally within DIF, would they move to another project? Did they leave the company? I don't know. But I do know that this caused operational problems for everybody, because I don't think a proper handover was done. And this was stated clearly to the senior management team when we had the meeting.
Okay, one last question. Do you recall a meeting that you held with DIF and in which you admit to release an immediate payment as far as the holding works will be done October 31st, and that you send an email on that?
Again, any meetings that we had and took place in relation to payments, this would have been done directly through the managing partner of RAFID GOURMET. My job and my role was more operations. I do recall on a number of occasions, Mr. Faisal and Mandel, in good faith, wanted to proceed. But again, the work that was done on site and after the visit that we had done, not only to the fabrication unit in Sharjah, which we visited, which was again, it was an outdoor yard. And it was quite humid at the time. We were concerned, but there was also a lot of damage and the finishing on the furnishings, also, which we went and visited and took pictures of and shared with the guys. The colors were not correct. There was a number of items missing. So, you know, a lot of these things, I mean, we tried very, very hard. I personally tried very, very hard. I was very assistant to the guys, anything that they needed to be done. But it came apparent very quickly that they were, you know, there was a lot of major problems that we had, not only on site but off site. Again, in relation to your question, you know, any meeting or any any payments that would have been agreed on, which I do recall a meeting similar to that. But again, this would have been through the project manager, Natasha, and Faisal Al-Mandal, our vice chairman.
Mr. Take, when you refer to the damages on the works done on site, the place,
Yeah.
did you even repertoriate or itemize this damages to the client on time? And did you ask for remedy or any correction? Because we didn't see the cause of the termination based on the damages, while you
Well,
put it on other ground.
Well, I'm not saying that I'm not saying that there was a clause for cancellation because of damages. When the guys were asked to stop working, it was basically due to the fact that the work had not been completed, and within the agreed date that we were supposed to open, we knew that the project was not going to be finished on time. So we had to have, at that point, we were then considering to look for a new contractor that would be able to bring the project in. You know, to be honest, all confidence and stuff like that had gone at that point for DIF to complete the project, you know.
Okay, so if I follow you well, it means that even in the event any second payment has been released at that time by the request of the defendant, because he considered that he achieved 30%, you do consider from your side that even this payment has been released, my client couldn't reach or couldn't match the date of delivery date of the December and December 2021. This is what you mean in your.
No, what I mean is that when we asked the gentleman to send us a correct process flow or workflow, because there was already delays and they had not achieved the amount of work on or off site at the time for the second payment to be released, we asked them to then send a proper workflow, because what they had sent us, it couldn't be followed. It was pointless. It was not something, a proper SOW sequence of workflow that you would follow. The template was not correct, and there was no accountability within it. So this is where we started facing problems in relation to. I do recall Faisal saying, "Look, I have no problem making the second payment, but show me. We've went and visited. We've seen that the work is not done on site. Give me a proper plan to follow." Because at that point they had completely failed to do that. Give me a plan. So he says, "Okay, it's one thing saying a percentage of work, but also give me a correct SOW to follow, that we know, okay, this week this is to be completed," so that there's some level of transparency there, which there was not.
Okay, I agree with you that first you had many meetings with my client on the ground, but which I'm not sure about its veracity, that when you say the workflow was not properly done and understandable from you. And the second, when you say in your meeting, one of your meetings, which is a key meeting for us, that an immediate payment will be released as far as the hoarding works will be finished as October 31st. In my understanding, my client has finished the hoarding work at that date. So why their payment wasn't released, if I have to say it like that?
Look, to be completely honest with you, in relation to the hoarding, you're saying that the work was complete. On the night that the hoarding was supposed to go up in the restaurant, they sent a gentleman in that didn't even have the documentation to stay to monitor the hoarding work being done. I had to let him go home, and I had to stay on site myself to monitor the hoarding work going up. You know, as I said to you, it was not that the hoarding work was complete, and for them to send a gentleman in that didn't have the correct documentation from CID to monitor the work that was being done. Understand, my role was just to observe and to be there to be, you know, if anything that the guys needed. This was also even a problem with the team. They hadn't got the correct documentation in place. So again, I think we need to be a little bit more specific on dates and what it is that you're actually asking me. You keep reverting back to the hoarding. Now, I've answered the question as best I can. I have told you there was issues. You know, when we say the hoarding, this is the covering that covers the front of the restaurant, not the facade where the steelwork was damaged. Also, in the design that they had for the hoarding, there was no exit door. The design they put forward that they sent to the hoarding company, there was no exit door. Had I not have been there that night, nobody would have had access to the restaurant or on site the following day. There was no exit door. So again, I think maybe you need to be a little bit more specific in what it is that exactly that you want to know from me, because I at no point, and believe me, I was on site most days. I was in contact with the guys. I was monitoring what was happening. At no point did the guys have the amount of work done that they were specifying.
That's your cross-examination. Thank you very much. Any re-examination, Mr. Bond?
Yes, Your Honour. Just on the matters raised at the beginning on Mr. Segaya. Mark, my learned friend asked you about Mr. Segaya Rajakudapan of Good Faith Auditors. You've told me you don't know who he is, and I'll just try and prompt your memory by reference to his witness statement, if this helps at all. But he was engaged by DIF on the 14th of January, and he then carried out an assessment of the works. Now, the question that was discussed a little bit this morning in the court,
Yeah.
whether or not he ever went on site. Now, are you aware of anyone on the 14th of January or afterwards, any time after the 14th of January, going onto the site and assessing those works, except for Natasha, perhaps, or the replacement contractor?
No, because basically nobody would have went on site unless they were accompanied by either myself or Natasha.
Right.
That would have happened. They would have having to make that known that someone was coming in. Common sense. I mean, obviously, if someone was coming in to check the work that was done, I personally would have been happy about that, because I'm pretty sure they would have confirmed, you know, the amount of work which was done, which was the whole problem we had. But I don't recall meeting this gentleman ever. Maybe Natasha did, but I certainly did not.
Right. No, thank you. And Mark, sorry, you said that you, just this morning, that you thought the works were 15 to 20% complete. And you said in your witness statement that the site progress was around 10%. The 15 to 20%, is that the whole of the works? Is that the on-site and off-site, or was
Correct.
that your assessment of just... Right.
Correct.
So in terms of the...
Yeah, sorry.
Please, go on. No,
No,
please, go on.
Yeah, I mean, you know, and again, that I at the time I was trying to help this to push it along, you know, but it was worrying for me because, you know, the major part, obviously, the stuff that had to be done on site, because we knew that there was other contractors and there was a time scale to get specific things done, if you understand what I mean. You know, we had many meetings, you know, in relation to the screens and technologies that would be used, you know, the ceiling covering that would be used, you know, and then obviously to try and understand the time frame that the retail units and stuff would be ready. So, you know, it became apparent very quickly that they were not ready. And to be honest, I don't know. I personally would have thought when, you know, with a project starting, there would have been a lot more people on site. Within the first 2 weeks, that was not the case, and it was within the third week, alarm bells started to go off. You know.
Correct. Right. So just affirming that the progress of the works on site, you stand by what you've set out in your witness statement, that on-site progress only ever got to about 10% in your assessment.
Correct.
I have no further questions, Your Honour.
Thank you very much. Thank you very much, Mr. Tekwe. You are free to go now. Thank you for your evidence.
Thank you very much. Thank you. Bye-bye.
Bye.
Bye.
So, Mr. Ball, I understand that Ms. Abbas wishes to give evidence remotely too.
He does, Your Honour. We've, with the last-minute change to coming into court, has come as a surprise with Ms. Abbas. Originally, she was scheduled to go on about 5. I emailed her on the 6th of July, and
well, let's not have. I'm only really concerned with the timing today.
The timing, she's just messaged me to say that she would be available at 3:45 p.m. to join online.
Okay, can she come earlier?
Her message to me was that's the absolute earliest she can do.
Okay, well, in that case, we are going to have to take another adjournment.
My client can join immediately.
Well, that may be a good idea. What do you say to that, Mr. Paul?
I have no objection.
No, that would be great. Good suggestion. Before we do that, though, can we just look at this document so that I know what it is? And also, so we have, let's have a look at this together, shall we? I'm sure Mr. Bull hasn't had an opportunity yet to look at it. So it begins on the 24th of October with an email there from Mr. Tekwe. Good afternoon. So this is to Mr. Ali. First, the 5,000 dirhams per day. Can't stress the importance of working directly due by mortgage. As per the contract, the next payment should only be given against work completed. We propose the following payments. 20% will be released this week for all works to commence as long as hoarding goes up. 30th October. Then the response to that, please copy project team, especially Sruthin, Dilip and Mohi. Dilip is leading this now soon, so not sure. Then 24th, this email is the payments and confirmation. If you feel that is relevant, the rest of the team kindly forward them previously on blah blah. Then from Essam Bakush on the 24th, with reference to the change in payment terms, let's keep with the original percentage claim terms as below. As per bill of quantities, terms of payment, 20 advance, 20% against. So the suggestion that Mark made was apparently rejected by Mr. Essam. And then on the next page we have
24th October from Mr. Faisal. More than flexible with the revised given to another 20% advance is not what we initially agreed. Not a lot to ask. So actually it appears that Mr. Takwe made a suggestion and it was rejected by your clients. That's what this shows. And then then it picks up again on the 26th on the documents on file at page 252 on the 26th. Mr. Take writes again, after internal conversation with Faisal as per the agreed terms of payment within our contract as stipulated below, remaining payments would be released upon completion of the works, must be verified by myself. And then he actually sets out what was in the original payment document with the original dates. Regardless to any completion work dates forwarded by your team, will only release payments against work which is well within our rights, etc., etc. Cash flow, blah. And then the response to that from Mr. Bakush, 26 October. Our project team and finance team will confirm shortly. Then there's an email again from Mr. Bakush, this is page 250, 27th. Based on your email, please find clarifications, confirmation of payment terms, reviewed by project team and finance manager. Original agreement, terms of payment as per contract. Don't understand what that means. First payment, 20% advance, 20 April paid. Furniture has been delivered, stored to warehouse. This is in hand. Second payment against work 31st May. No work has been completed. We both agreed that the works are on hold due to EMA-related issues, and we are now ready to mobilize based on approvals being ready, which you've seen Edgar's asked to resubmit. We have seen the Form 3 for you to fill. We'll submit to we have to receive anticipated date 10th November at 30% completion of site works, works at site, factory, value of furniture. So that appears to be a suggestion there from Mr. Bakush, and then the response, hi, is from Mr. Take. Hi, Assam. Check this stage you've mentioned 30% completion. I need this confirmed correctly as per the milestones for the set completion work. Also, 10% retention. You are now requesting a PDC check, which was not agreed. Blah, blah, 10% withheld to safeguard. Okay, well, you'll have to both have to make submissions to me on whether or not any of that really amounts to a variation of the original payment provisions or not. I'm not going to express a view at the moment. But unfortunately, we're going to have to break now. Oh, no, we're not. We're going to take...
Yeah, look, I would just note that in relation to this email, it has been produced now today for the first time.
Yes.
It is not formed part of the bundle. It wasn't provided as part of, it wasn't attached to Mr. Fidali's witness statement, and it wasn't exchanged during the standard production. Now, the volume of documents exchanged in standard production was an issue raised before this court in the immediate judgment application.
Yes.
Because the defendant only submitted 2 documents. Both of those documents were already attached to its defence and counterclaim. So submission of this email, as I believe Your Honour has noted, that it isn't relevant, it doesn't show a change to the terms, but I think the emails that we have already on file are the ones that we should both be referencing, and not this email that's been produced.
Well, I'm frankly, for what it's worth, happy to look at this email rather than exclude it. I don't like excluding evidence if it's here. What one makes of it, as I say, will have to be a matter for submission. Ultimately, just reading through, I gave you my gut reaction to it.
Yes, that's
as
perfectly
always,
okay.
gut reactions can change subject to submission. So we will allow reference to this document. I'm not going to exclude it. In which case, yes, let's have Darley give his evidence. That was a sensible suggestion. Yes, so let's get him in and let him give his evidence, and we can move along. That would be great. Thank you.
I'll advise Natasha that she can log in at in about close to 3:45, as she suggested.
You tell her, no, you keep her at 3:45.
Yeah.
If she can't do it any earlier, that's fine. Good afternoon, Mr. Darley.
My name is Sharif Muhammad Salah Abdel Fattah Al-Fadali. I'm the owner and the founder of DIF Interiors. I swear by the Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. So Mr. Mukharazel is going to introduce your evidence into the record. You can stay sat down, that's fine. In front of you is a screen there. I'll let the documents come up on that screen. Okay, we're just seeing whether documents. Sorry then? He has them printed. Has them printed. Well, there may be other documents he's referred to, so.
My witness statement?
Yes, I know, but in cross-examination, counsel for the claimants may refer you to other documents which you will need to be able to see on the screen there. That's, and he has in front of him the, on the CMS? Yes. Okay. Okay, Mr. McNasel, would you introduce the evidence, please? Thank you.
Adali is the owner. Supervising directly.
I think he can give that evidence himself. Well, I think he ought to be giving his involvement himself. Yes.
He remitted his witness statement on 4th of April, 24th of April 2020.
Oh, yes. Would you like to get him to confirm that for the court record? Sorry, you need to take him to the witness statement. You need. No, it's not for you to confirm. It's for you to get him to agree that the witness statement is his signature, that it's true, and that he wants me to receive it as evidence in the case.
On that this witness statement.
Yes.
Thank you. Well,
Ali, Honor. Are you Gita? You're assisting with the bundle, are you? Okay. I'll start by referring you to page 2 of your witness statement. This is page 816 of the bundle. Adali, you've stated at paragraph 8 of your witness statement that you had agreed to the following payment terms with RAFID GOURMET. 20% of the contract value advance payment, 20% contract first progressive payment against 30% site works progress, 20% of the contract value second progressive payment against 60% of site works progress, 20% of the contract value third progressive payment against 90% of the site works progress, 10% on completion of the works and handover, and 10% post handover of 2 months. This is what your witness statement says, correct?
Yeah, correct.
And this was your understanding from day one, and by that I mean late April 2021, when the contract was first prepared and signed, that these were the applicable payment terms.
Yes, the agreed payment terms between us and the client.
I'll refer you to a copy of the contract, Mr. Fadali. It's page 159 of the bundle. You agree with me that this is a copy of the contract?
This is a copy of our quotation.
Right. But that is the contract that set out the terms in which the parties carried out these works?
Okay, in my understanding, if you tell me contract, this is not a contract, this is a quotation, which have mutually agreed between us and the client. Against the quotation, they should send an LPO from their end, or in a further stage, we sign a contract. Okay, so this is a commercial proposal, which in a later stage, we requested the client to share with us an LPO, but for some reason they did not share, and then we assumed that this will be the form of agreement between us and them.
Correct. So what you're saying, that there was no further document signed that set out the terms of this agreement. This is the agreement with the...
Between us and them, yeah.
I don't think you need to speak too close to the mic. I think it does pick you up. It's okay.
Mr. Fadali, just can you see where signed by Mr. Tekwe and stamped by the company? So that shows they countersigned this, and so that's what I think counsel meant by being the contract. So it's right, isn't it? They countersigned your quotation and it became the contract. Yeah.
Now, the terms of payment on this letter of the contract are similar to what you've stated at paragraph 8 of your witness statement, but they're not the same. Do you agree with that?
The same, 20, 20, 20, 10 and 10.
Yes, okay, but then there's some additional elements with regards to dates that are added in the contract, and the document itself doesn't actually refer to the 30%, 60%, 90%.
Yes, yeah. I mistyped it, I think, or.
So would you agree that despite the difference between paragraph 8 and the contract, there was a common understanding on this project that the first progress payment would be paid when DIF achieved 30% site works progress?
Yes.
Did you draft this document? You did? And that is your signature at the bottom of the page there?
Yes.
21st of April, you sent to RAFID Gourmet the invoice for the advance payment, and that was paid 7 days later. Is this correct?
Yes.
This was sent on the same day as the contract, but paid before the contract had been countersigned, correct?
We're talking about the day of payment, which is 21st of April. We've sent the invoice.
Yep.
And 28th of April, the claimant has paid us.
And then on the 9th of May, the contract was countersigned and stamped by RAFID Gourmet.
I don't know about
It's on page 159 of the bundle, at the bottom there.
I think it's in Mark signature. So it's
Correct, and it has the date there of 9 May 2021. And then there was the delay. Now, we've all dedicated a lot of paragraphs to this period of delay. Both our witness statements and your witness statement deals with it. But in summary, all that fundamentally occurred is that the parties agreed to push the works back until the permits were issued. And when the permits were issued, both DIF and RAFID Gourmet were ready to resume by the 1st of November 2021. Would you agree with that very broad overview of the delay period?
I just want to highlight something, that I have tried to push the commencement date of the site till 17th of November because we were busy, and as you know, we were supposed to start in June, I think, but then pushed till November. So we had some other work to do, and we had to reschedule our resources. But eventually, I met Faisal in the Palm Hotel, and I told him, okay, I will try to manage by the 1st of November so we can restart the project one more time.
So when the project was about to begin, no one had any claims against each other for delays. There was no blame backwards and forwards on who was the cause of the delay. This was all just a matter that both parties had handled in stride, and coming to the 1st of November, the works were ready to start.
Not correct.
Not correct, okay. What would you say?
Because there is things happen between this period of time, and I think I have submitted all these emails to our lawyers. We did not actually understand why this project was not going to start the date that we assumed. And we received several mails from the client, the claimant, accusing us that we are not able to source the permit to work from A'mar. I have personally spoken to A'mar, trying to understand why A'mar doesn't want to issue a permit to work with us, and I wrote in my witness statement that the heating up situation started there, I think, where we did not understand what is the real issue for us to deploy our manpower on site. That is why I interfered with the team, and I called A'mar directly, and I understood that there is some kind of rent issues between the claimant and A'mar. That is why they will not give the permit to work until the client, our client, RAFID Gourmet, sort out the rent issues with A'mar. This information reached to us, to me personally, over the phone from I'mar RDD team, and it was never communicated to us directly. So we did not really understand why we cannot start the job. Within this period, there was emails between us and the clients accusing us of delay, and accordingly we reply back that please contact I'mar. There is issues between you and I'mar. Please sort it out, and then we are ready to start. However, this took almost 5 months.
Is there any emails attached to your witness statement that reflect any of this?
No, I called Mr. Muhammad Bahr from I'mar and Karim Ghannam. Basically, they are in the industry, and I know them. And this was over a verbal communication by phone.
Say at paragraph 23 of your witness statement that on the 21st of September 2021, you met with Faisal and Mark at the 5 Palm Jumeirah, and you say at this meeting, I have discussed the plan in detail with Faisal, and I made him aware that we would need funds soon after deploying manpower to site to accelerate the works since we did not have time to waste. Do you agree that this is what you stated in your witness statement?
Can I elaborate?
The question's only, is that what was stated in your witness statement?
Yeah, see, I met Faisal, yes, in this date, and I explained.
We do talk about this meeting, so if I ask questions about this meeting, if there's any things that you want to add on afterwards, perhaps we can deal with it then, but I'll just continue in terms of these meetings and discussion. Then say that on 18 October, you, that RAFID, you say in your witness...
Where are we in the witness statement, please?
Close to paragraph 23, Your Honour.
Yes, I have it, thank you. Carry on, please.
Say that on 18 October, I'm sorry, I just need to try and find it. I'll just try and find it. Okay, so paragraph 23 still. Say that on 18 October, informed Mark via email, dated 18 October, the DIF will not be in a position to commence the project by the 1st of November due to some other project commitments.
Yes.
And sometime after that, UKESH has agreed with Mark that the project would start on 1 November, is that correct?
No, they agreed on 17th, but again, Faisal, I agreed with Faisal separately, and I pushed my team to push back the date into, I have a paragraph 25th, which I pushed everyone to start 1st of November.
Say paragraph 23, after agreeing, now I may just double up a little bit here in relation to that start date, but after agreeing between Mark and UKESH on the proposed new handover date, it was extremely important to work closely together and open the communications to achieve the target and the opening date. And I've informed Faisal that once we are at site, I would need his support to release the first advance payment straight after demolition of all existing cafe. Is this correct?
Yeah, correct.
And when did you say this to Faisal? Was this at the 5 Palm Jumeirah meeting, or was this at another meeting, or was it perhaps by email?
Can you say again, please?
That statement that when you said you told Faisal that you would need his support and the release of the advance payment straight after the demolition, when did you say that to Faisal?
Paragraph 23 and paragraph 24, this is a conversation took place in the 5 Palm Jumeirah between me and Faisal. I understand, I'm a contractor, I've been working here for 16 years in Dubai, and I understand when a client loses a period of time just negotiating new rent with Amar and then the sales have been affected. That is why I agreed to push everyone in my company to start the job on 1st of November. But the situation in this discussion, basically, it was, I received 20% advance payment. I paid 50% of the loose furniture, which is coming from Greece. And I explained to Faisal, which I wrote in details in the next page. What I have discussed with Faisal, I did. I told him, Faisal, I have less than 60 days to complete this project. So the project relies on a contractor who can really deliver, and we need to pump money into the project to help us accelerating our progress on site. And my impression from the meeting that Mr. Faisal understood what I was talking about. I told him, which I wrote in the item number 26, I told him that I we will push the timeline.
Okay, all right.
And accordingly, if there is these emails we have submitted before, UK and Mark, they have agreed on 60 days from 17th of November.
Okay, okay. No. Point me to an email or any document where you confirmed this request to Faisal in relation to the payments being made as soon as the demolition was complete.
There was a verbal conversation between me and Faisal.
So shortly before the works began, it was Yukesh who was having the discussions with Mr. Take and Mr. Almandal in relation to the plan of the project, correct? What is Mr. Yukesh's role?
Project manager.
He was the manager of this project, right? I'm going to refer you now to section, well, I'll just jump to page 248 of the bundle. This is the works program. You familiar with this document?
When this was shared,
Yeah, that document?
not me.
Okay. When that document was given to Mark in October of 2021, was this DIF's plan in which it intended to carry out the works?
Yeah, I believe so. If we have submitted a timeline, so it's our intention to finish with it.
In paragraph 25, you say that you agreed with Faisal to start the works on 1 November and hand over on 31 December.
Yeah.
There's a little bit of a grey area here in relation to the 31 December date. Marcus said it was 30 December. The program shows the hoarding being removed on 25 December. But essentially, was it agreed that the works would be completed and OPSO Cafe would be open on New Year's Eve of 2021?
Yeah, originally, yes.
Do you appreciate the importance of the timing of this opening, the significance of those premises on New Year's Eve?
I don't understand.
Well, as we know, the restaurant of the cafe of OPSO overlooks the Burj Khalifa fireworks, which is an annually prestigious event. Would you agree that it's fair to say that there was importance in terms of the project being completed before that event on the 31st of December 2021?
I agree on the statement. I do agree that it was very important for everyone to open before the new year. However, have you seen the site yourself?
Yes.
I've been there. So you may know that the cafe area does not impact the restaurant area. And the cafe area doesn't have any relationship with the fountain and the fireworks that happened in the new year. Have you seen the design?
Okay, so I'll just clarify with you, but would you agree that for those patrons of the restaurant, walking past hoarding of the cafe is not nearly as desirable as walking through the brand new cafe with its launch?
As a statement, yes, I agree for sure.
Do you know if it is Mr. Yukesh who prepared that project plan that I referred you to on page 247 of the bundle?
No, he did not prepare it himself for sure. We have had people working in the company, and it should be done by a planner. So, but he supervised the work of a planner.
So the project manager wouldn't prepare that drawing
Himself.
Would he have input on the, as a project manager, would he have input on the?
For sure, yes.
Not drawing, sorry, the chart, the Gantt chart.
Yeah.
Yeah. Why is Mr. Yukesh not here today giving evidence? Why did you not elect to call Mr. Yukesh to give evidence in this case?
Yeah, because Yukesh left back in India at that time, and to be honest, I would not involve him to come and witness on something from India. So
no,
I
that's
had to,
fair.
Yeah.
When did he leave?
I think in August or before.
August of which year?
2021, just before the restarting again of
Okay.
of also.
But Yukesh was at the meeting at the Palm, December. Yukesh was the one that agreed the date project, the projects to be 1 November to 31 December.
No, he was not in the meeting.
Paragraph 23, you say that Mark and Yukesh agreed the dates.
But via email. By mail. Just to the date that Yukesh left, I can get it for you.
Okay.
So I'm not sure exactly.
Perhaps it's in October, just before.
Yeah, probably. I really
He's the
don't
project manager of this project, and he leaves days before the project is started.
I don't know in which date exactly he left. But I know we have had, maybe, I'm not sure, but it was maybe a month and a half or 2 months, something. I cannot recall now the exact date when he left the company.
Paragraph 27 of your witness statement, you say that on 24 October, Mark tried to change the payment terms. You didn't agree to those changes though, did you, Mr. Fidali?
No, we did not agree.
Then at paragraph 28, you state that you and Assam put forward your own payment terms in an email dated 27 October. Is that correct?
No, we were trying just to understand why Mark.
Yeah, but just in terms of what you said in your witness statement, this is what you've said at paragraph 28. Is that right?
Can I read it? Just a second. Yeah, I mean, this was the discussion that took place between Assam and Mark, just discussing payment terms, the changes, why, and so on.
Can we have a look at page 251 of the bundle? This document we have, this is the original email from Mark Takei, and it has, so I'll just bring it up on my computer so the
Probably better to start at page 250 so the witness can see the heading to the email.
Sure. Yes, Your Honour, thank you. Page 250 is where it starts, and it's a chain of emails that flows below that. If we scroll down to the email of Essam Bakush on the 27th of October, there is a bit of, some notes added to the original payment terms that has been floated backwards and forwards between the parties. And so my understanding is that the text in black was written by Mark, and then you've added the text in blue. Would that be correct?
I assume yes. Yes.
Yes. Okay.
I mean, when you say you, it's not his email, it's Bush's email.
Well, can you clarify that, if this was Assam or yourself or both of you? Because I seem to get the impression from your email that you both had a part in drafting this email whilst it was sent by Assam.
As I said in the item number 28, I let Assam conclude this with Mark.
So there's text in blue and there's text in black, and I was under the impression that perhaps one of you drafted the blue and one drafted the black. Is that possible? No, so Assam drafted all of this. Okay.
I think he just copy-paste. This is my assumption, because he in black it's written original agreement. So terms of payment as per the contract, first advance 20%.
Yeah. So sorry. So when I say black, I mean the second black.
Yes,
so
there are three stages to this. So if you look, for example, if you start with number 1, first payment, and you see 20% advance, 20th May paid. That's from the original quotation countersigned. And then you've got the blue. Actually, with 1, you don't have any further comment. But if you go to 2, you'll see that then there's a further comment in bold black. So it's obviously original, some comments on it, and then a further comment.
Sorry, carry on, Mr.
Yes, sorry, just lost my place on my queries. So, Mark and Faisal never agreed to these notations, though, did they, Mr. Fadali? Can you direct me to an email or document where Mark or Faisal agreed to the words that were added here, and I mean the words in blue and the second black word, terms in black?
For instance, you're talking about item number 2, this second payment, 20% progress. 20%
Yes,
progress
precisely.
payment.
Let's focus on that. That's the payment that stalled everything. Have you got any confirmation? Can you direct me to any confirmation that what is written in this paragraph, number 2 on the second payment, was agreed by Faisal or Mark? You have confirmation that that was accepted?
Yes. I believe there is a correspondence came from Mark.
Okay.
In a later stage.
Right. Because if we do scroll up, we see Mark's response on page 250, the email of 27 October. Mark clearly pushes back here. He asks UCAS to correct the email and resend it. Interpret that as acceptance of those terms?
For completion of 10%
Well,
reset.
hold on, before we do anything. Mr. Takwi's email is dated 6:03 p.m., but Mr. Bakush's email is dated is at 18:33. So on the face of it, it doesn't look like it's a reply to that.
That's an unusual.
मतलब क्वालिटी थोड़ी सी डाउन हो जाएगी क्योंकि ये तो हमें YouTube पे नहीं डालना, YouTube पे वो डालेंगे हम। मैं इसका रिड्यूस करके भेज देता हूँ आपको, ठीक है?
Sorry.
It's just the.
Oh, it's okay?
Yeah.
This is all right. Okay. I can only assume, Your Honour, that perhaps one of the parties was out of the country. I don't know how it would be possible to do this unless there is a time difference issue here.
Well, unless somebody misset their clock, but also the CCs are different. Are they?
I think it's safe to say that he is replying to that email.
Why?
Just by the context. I don't know the technical answer to this. I can only assume that maybe Mark was perhaps in Ireland as he is now and has responded, or perhaps Essam was in India, but in either of those circumstances, that would mean that 1633 has occurred before 6:03 p.m. when Mark has responded.
Some was here.
No, if you're in India, if you're in Ireland, means that
The other way around.
it's the other way around. It's only if he's in India. Well, anyway, I'm not wholly convinced it's a reply.
Matter I'll have to look into. I hadn't noted that.
Nothing may tell on it, but
I think that's probably the case.
no, actually the CCs are the same. Yes.
Okay, so anyway, if we get back to, perhaps we go to paragraph 29 of your witness statement. We've noted here that it was your understanding that everyone would adhere to the original payment terms and this was acceptable to you, correct?
There's one thing here. Question. Have tied in page 2551. We have now talking about milestones against payments. So we have two factors here, a timeline and the overall progress. Fine? And it's the best way to manage a contractor where you tell him in this date, if you hit the milestone, if you give me this progress, I will pay you. So having the understanding in general that the second progressive payment against work progress without looking into the date, you have the wrong understanding to the payment terms because we connected into dates here because of the timeline of the project. That is why we have shared the timeline with Mark.
Yes, but I put it to you that Mark never accepted this.
Well,
can I ask you this? I mean, you said that it's connected into dates rather than, are you saying, sorry, let me clarify with you. Are you saying that it was agreed that the payments would be made on particular dates? Are you saying that they would be made for milestones, or are you saying they would be made for percentage completion? All three are different.
Yeah.
So
Okay.
which is it?
So we have agreed that when we will reach 30% completion on this date. Okay? So
That's a target date then.
that's a target date, so I need the money to come on this date.
So I think in fact the parties are agreed on that then. So 30%
So
achievement.
I think the overall story is that essentially, as you said, paragraph 29, that you would adhere to the original payment terms, and in paragraph 8 of your contract, you've set out those original payment terms. You said earlier today that they are the terms that you agreed from the outset, and you've affirmed in your witness statement that those are the terms that apply.
Yeah, but I agreed to the
Okay.
original
Yes.
because the finance team in the company, they saw if they're gonna deviate from 2020 or to 2010, that will affect our progress.
Right, so it's, yeah, okay, so paragraph 8 is correct, as you've confirmed this morning, earlier? Yes, okay. Whole story here, Your Honour, and as a matter directly related to the points raised by my learned friend, is that the payment terms never changed.
No, it is changed in a later stage. Can you
Oh,
allow
later on,
Can
you're
you-
saying that after, okay, we will carry on and we can talk about this. Paragraph 26 of your witness statement, dot point number 1 at the top of page 818 of the bundle, you say that on 30 October you paid the following amounts: 74,385,
Yeah.
50% advance payment for interior 360, 117,982 advance payment for the custom-made joinery, 21,840 full payment for the intrametal against fabrication of 8 chairs, 5,680 advance payment for the internal hoarding and artworks, 11,000 100% payment for the LCD screens, 5,500 for the blue colour curtains, 774 dirhams loose materials, 2,800 decorative long lead items, and another amount of 1,300 for decorative long lead items. Correct?
Yeah.
Except for the LCD screens and the blue curtains, all of these payments were advance payments to those suppliers. Is that correct?
Yeah, correct. No, the 1,360, this is full.
Okay.
2,885 full. 774 is full.
Your joinery provider has provided us with documents to say that you paid him $117,000, but he has said that it was paid on the 31st of October. You said here in your witness statement that the payment was made on the 30th of October. I'm not going to make a fuss over a day, but it was the case that from the 28th of April to the 31st of October, you held on to the advance payment. You didn't spend the advance payment in May, did you?
What we have spent, look.
No, that's your answer.
Sorry?
You didn't spend the advance payment in May, did you?
The advance payment of the client?
Yes.
We spent only 74,385 for the loose furniture.
Okay.
Okay, and
but your witness statement says you made that payment on the 30th of October. So
I mean here on the 30th of October, we have already paid all of this. I mean, there is one maybe wrong date between the check of the joinery, but all these payments have been made before us receiving any further payment from the client.
Further payment, right.
Finished. Theoretically, I have not mentioned here any overheads or engineering or staff salaries, people working on the project. This is just a raw spending, money that I have invested back into the project without charging the client any overheads or anything.
You agree that the 117 was in fact paid by way of a check on the 31st of October?
Yeah, and we have a copy of the check, yeah. I thought you were asking why October when I received in May.
No, I'm pointing out that you had the benefit of the advance payment sitting in your bank account from May to the end of October.
It's
not paid?
Look, as a company, I should have charged the payment and engineering and overheads, people working, meetings. I went myself, and I can give you a hourly rate. So I did not charge this. What I have done, because I knew that I had to keep this money for when the project kick off, I have to spend it. Otherwise, I will be in trouble. So I spend what I have to spend for a long lead item, and the remaining I kept it. And we have sub-accounts in the company, and at the time came to kick off, I started spending again.
But the contract doesn't have any terms on this, does it? There are no delay terms in relation to delays. There's no terms in relation to suspension. The suspension was agreed by the parties, and everything was put on hold.
What I'm telling you, this is not a contract. This is a quotation which has been signed. It has to be elaborated to a form of a contract.
Correct, but it wasn't, though, was it?
Yeah, where if the client is late, I should charge him more prims to the contract, which I did not, because I understand.
Because the contract was never drafted. The contract was never signed, agreed, exactly. On the 30th of October, EMA approvals were issued. Is this correct?
Which paragraph we are now?
29. But I believe that's an agreed fact with the parties.
Yeah, in the 30th of October, Amar has issued permission to erect the hoarding.
Yeah.
This is different than the permit to work. It is different. When you work in Amar, there is kind of permits here. What we have got on the 30th of October is a permit to erect the hoarding only. And then there is another permit, which is the PTW. It came in a later stage when Amar reviews all the drawings, all the technicalities. At that time, they allow you to start the real construction. You know what I mean?
Yeah, but where is that referred to in the contract? As far as I can see, in the project plan that was agreed between the parties sets out that from the 1st of November to the 31st of December, the works would be carried out.
Yeah, because, okay, may I ask you, what is the definition of work should have been carried out inside?
The program I referred you to, the program that was prepared by DIF and provided to RAFID GOURMET, it sets out a clear process of everything that would be done.
Yeah, but if you look to the clear process to our program, can I explain something to everyone here? Can I just demonstrate something to the court? Okay. I'm an architect, and it's very important for me to let everyone understand what was the exact scope of work, what exactly we were contracted to do in OPSO. I have here, can I get this closer to the torch?
I think these matters should have been set out in your evidence in chief.
No, I need to explain this, please.
What is this?
These materials I haven't been provided with.
This is the design. This is it's an MR portal, and I did not get something which is not there.
Show it to Mr. Bull, first of all.
Yes, this is documents not included in your witness statement, Mr. Fadali.
We have the submission to MR. I mean, it's easy to pull, or at least, if I may, I will talk from my BOQ, which I put it in my statement.
Well, so you've set out the matters you wanted to state in your witness statement, and I'm questioning you on those matters. So we'll try and keep it limited to that, okay? On the 31st of October, at 2 a.m, the works commenced, and you say that at paragraph 30 of your witness statement, our team has coordinated with the appointed mall contractor, McDassey, and we deployed our manpower to start the site works. I put it to you that DIF wasn't on site that morning, correct?
It was not morning, it was night.
2 a.m, 31st of October, 2 a.m, so we'll call that the morning.
We were
understand.
there. We were there. Look,
You were there?
Our team.
Right.
Look, this planned, it's a long procedures, and it has to be planned with the CID, the police, the mall authorities, for us to erect a hoarding. So we have to be there. Usually they erect the hoarding after 12 o'clock when the mall shuts down.
Perfect sense.
So our team was there from 12 o'clock all overnight till morning.
The evidence of Mark Takei is that you weren't there. He had to stay back and oversee those works.
There has no, okay. I have read the email of Mark, and just a matter of logic.
So let's just go to that email. That's page 256 of the bundle.
I know the email.
There's an email sent by Mark at 3:35 a.m.
I know this email, and I completely reject the statement that our team was not there at the time of erecting the hoarding. It's the permit to work is under our name, and it's a very complicated process to work in AMR properties. We hold the permit to work, so we have to be there.
Well then, what's your explanation for Mark Takei taking the time to write this extensive email, must be close to 700 words, at 3:35 a.m. in the morning, and then the response from DIF, Mr. Bakush, is, "Dear team, please make sure the communication is directed to you." Oh, sorry, this is see below mail from Mark, which requires addressing to avoid, minimise any future issues on site. That certainly does not say Mark. That email is completely made up. What are you talking about?
The answer here is Isam is a director in the company, and when he received an email from the client says that we were not there at the time of erecting a hoarding, when you read carefully what he wrote, he addressed it to the team, and he said, make sure that there is no issues coming to us as a management again or anymore if there is any issue.
Right, but he opens that email by saying, "I hope moving forward things are more organised from your side. your team did not arrange the security pass required to be on site tonight to supervise the hoarding construction going up, nor sent details for the permits required to enter the premises for tomorrow.
Then how?
So Mark at 3:35 a.m. wrote this for no reason, or it was.
Then how did we erect the hoarding if there is no one from our?
Dusty erected the hoarding.
Who supervised them?
And there are
Again, who was allowing Magdasi to come start erection of the hoarding?
Well, Mark was there.
Us. Mark have no authorities to start this process inside Amar.
Mark represents the tenant, though.
Doesn't matter. He doesn't have the permit to work under the permit.
I will let the court decide the most
permit
likely outcome.
is issued to DIF, not to Mark.
Despite this, works got underway a day early. You agree with that?
Sorry?
Essentially, by the work starting on the 31st of October at 2 a.m, you're starting off one day ahead of schedule. Is that right?
But, okay, to start what? Erecting the?
The works. The works are underway.
Erecting the hoarding. So to allow us, this is what I wanted to explain to the court.
Let me just, what is the purpose of erecting the hoarding? It's to close off the premises so the works can start, correct?
To prevent the end users, the mall visitors,
correct,
of seeing what's happening inside.
Correct.
Yeah.
So there would be no sensible reason to hoard off a site and do nothing with it. Cuts off the business that was there, because there was a cafe operating before you started. This was a refurbishment, correct? Saying that RAFID Gourmet and the mall, DIF, rushed on the 31st of October to get the hoarding up, only to then wait for further permits.
Well, the technical permits, which is, I really need time to explain technically the job, because
I understand the job. The job's to fit out the refurbishment of the cafe. Between the 1st of November and the 10th of November, how many times did you go onto the site?
Myself?
Yeah.
Well, I'm not supposed to go to sites.
That's fine, that's fine. So about how many people from DIF how many people did DIF have working on the site over the first 10 days?
There is a team. There is a demolition team.
What's the general number of people are we talking?
I'm not sure. I don't know the answer of this. There is a manpower allocation.
Okay.
Been arranged by our team. They deploy the manpower that is needed to get the job done.
Okay. Marcus said in his evidence...
Can I ask you this? That you knew clearly that the allegation in this case was that you didn't have enough labour on site. And so you weren't progressing the works. I mean, that's what this case is about, right, isn't it? They're claiming you didn't have enough labour on site, you weren't there from the 17th of November, and so they're saying you undermanned the site. That's right. Well, that's right. That's their claim.
That's their claim.
Yes, exactly. So you could disprove that by your site diaries, which would show what labour you had on site.
Yes, and we have.
So why haven't they been produced in this hearing?
Because our understanding, that is not about the sufficient manpower or no, because I have pictures with evidence that in a certain point of time when Mark was not really, we tried to educate the client that there is a certain job to be done on site and there's certain jobs, the measure of the work is to be done in our factories. This is why I want really to explain to the court. Because I put it here in my witness statement. If we go through the BOQ, let's say that this is the cafe area.
No, we've your
Can
BOQ is
I
in
have
here.
my chance?
Your BOQ is in here, and we can address that. You've had your say on that. You've had with your counsel. You've prepared your evidence in chief. And in relation to that, I just want to talk about the points that you've raised and the points that I want to query.
Okay,
we'll
fine.
stick to that. All right. Marcus said, I don't know if you've seen this allegation, but Marcus said, it's in his witness statement, that on one evening in the first 10 days of the project, he locked up the restaurant after it closed and he left. And during that time, there were DIF employees on site. He came back 2 hours later and everyone was gone. Could you explain how this might be possible and how Mark may have seen that?
Okay. There is so many scenarios here. The first scenario that if we deployed manpower to work overnight in a shopping mall, it's impossible for all of them to leave in one go. Second scenario, they have tea breaks. Maybe Mark came in a tea break. I don't see any reason for us to deploy it. We lose, like contractors, we lose money if we deploy manpower to a site and we pull it back. This is a loss. So the common practice, we cannot do it, especially if we have permits for those guys to enter this facility or building. So I don't really understand why every time Mark goes, either our guys are not there, or they left, or he has seen them and then he left. This is why I did not understand this kind of image. What is behind this kind of image? And I wanted to, I actually explained to Mark so many times, when you look to the first 10 days of the site, we have finished what is required for us to start a different stage. So on site, in the first 10 days, we have finished all our demolition. We removed everything on site. We have built, we have done all the enabling work. We have done all the partition required, and we were fabricating. So the amount of work needed to be done on site, it was not major work. On site, I finished everything apart from painting the ceiling, which we did not have approval for the color code. Till December, or maybe more than December, I don't remember the date now. But whatever work need to be done on site, we have finished it, because we are the expert to deploy how many guys. Some of the people, they come and say, I need 100 people here to do what exactly? If the job, 10 guys, they can do it. And I have finished it within my timeline. The remaining, the major, it was fabrication work. We already were working outside of OPSO. And not to mention that there is a big part of the design was put on hold by the client himself, because they were rebranding, doing new rebranding. So when you look to the OPSO cafe work, flooring stays as it is, the complete ceiling stays as it is. I am fabricating some custom-made cabinets, okay, which I have approved that I have fabricated more than 60% out of it. The remaining material, I need approval from the client and the designer, which does not come to us as a contractor. So
okay,
you have to look from our perspective. If when you ask me that I don't have a sufficient manpower, I finished whatever need to be finished at this stage.
Right, so
okay,
at the 30th...
sorry, can I... Could you please go to page 510, which is the program? Can you have that? Yes? Yeah. Okay, so looking at the program, from the 1st of November, we've got hoarding installation, demolition work 6 days, shopfront glass 6 days, so that's 14 days. Then there's flooring, which is waterproofing, cement screed, installation of white Carrera. So we have 14 and we have another 10, so that's 24 days there. And then partitions and modification of existing work. All of this is on site, obviously. Installation of partitions, supply installation of wall cladding. So that's another 11 days. So even before we get to the electrical and so on, are you saying that all of that was completed within the first 10 days?
Yes. Because the job is very simple.
But then why is it planned for such a long period?
I would just point out, Your Honour, actually some of these are running
the
concurrently.
custom-made fabrication that takes time outside.
This is some of it's concurrent.
That's correct.
Okay.
Yes. So it's essentially the cement, sand, screeding that goes up to the 11th of the 11th.
22nd of the 11th. We've got installation of white Carrara marble effect porcelain 22nd.
That never started, and that was
Wall cladding 16th. Second fix electricals 18th. Not sure I know what DB dressing is. 24th.
plan as well, Your Honour.
Sorry?
I just point out this is the plan. We actually, as we go forward, there is
This is a program.
a program. Yeah, there is a program that was done contemporaneously, which showed the progress that was actually achieved.
Where's that?
We will come to it shortly.
Okay, you want to come to it
Yeah.
your own time. Yeah, that's, I understand.
Okay, but that will be made clear.
All right, no, carry on.
Did you have workers across multiple sites during this period?
Multiple sites, yeah.
Right. So we've already noted that on the 18th of October, you were against this project starting on the 17th of November. Is that correct? This is what you stated in your witness statement.
Not against. I told Faisal clearly that I will have to check with my operation team for the manpower allocation. No, and then I agreed because there is a phone call. Faisal called me and said, Sharif, we really need to start 1st of November. So I took a decision on behalf of everyone and I pushed everyone to start 1st of November. So I'm not against. I was not against. Yani.
Is anyone on site during the first 10 days of the works? Is anyone on site during the day? Why it works or works?
Just, I think few guys, because there is no, we are not supposed to do any noisy work. So during day, nobody is there. Very few guys just cleaning, doing unnoisy work, and then at night we start.
Paragraph 31 of your witness statement, you refer to a meeting that occurred on 11 November. Wondering if you mean the meeting that occurred on the 10th of November at all. So, this is the meeting. The one on the 10th was the one that was called by Mark. So, are you referring to the meeting on the 10th of November?
He requested a meeting.
Or was there a further
the meeting
on...
took place on 11th, I think so.
Right, but if it assists you, Mr. Fadali, Mark has said it was the 10th of November, and the email he sent to DIF at 10 p.m. on the 10th of November Mark has stated, and I quote, I just want to recap on our meeting today.
Have we got a number for that, sorry?
Yes, page 259, Your Honour. See there on the first paragraph, well, you see at the beginning, it was sent on the 10th of November at 10:20 p.m. Just want to recap our meeting today. Supposed to receive minutes of the meeting, which was not received. So we agreed that we're talking about, in this witness statement that you called the meeting of the 11th November, we're actually referring to this meeting that was, in fact, on the 10th of November.
I think it's the same meeting.
Okay.
Yeah.
You at that meeting?
I was not there.
Say at this meeting, Mark Takei mentioned variations to the approved design, and you say that this put on hold the entire facade works. Yeah. Is that correct?
Yeah.
Show me any evidence that Mark said this.
We actually communicated there is several emails which we submitted before from Yokesh and from Srutin, his assistant, that, and from Dilip, not Yokesh, Dilip, that time, because Dilip was the appointed PM, that the facade work was put on hold.
But in the documents that you've provided to your lawyers, in the evidence that you've given, there's no evidence that, apart from your statement, that this is what was said at that meeting. Is that correct? It's a meeting that you weren't at.
Let me read just the...
So you didn't see an email on that point, did you?
Okay, if I just need to understand more your question. If there is any design change, okay, has been communicated by emails between the two teams, kind of confirmation you're asking for. If there is a
Well,
new
I'm
design,
saying that there was a meeting
shared,
on the 10th.
okay, if there is
And
a new
you say,
design,
or you say at that meeting, variations to the facade were discussed.
yeah,
I'm saying, prove it. I'm saying, firstly, you weren't at the meeting, and secondly, you've got no documents to verify.
there is
this
documents.
statement.
We have documents from
I know.
Dilip, which have sent it to Mark as a meeting minutes that there is a change on the facade.
Right, but there's no documents that your lawyers have put forward in the bundle that verifies what you're saying right now. But you can't refer me to a page in the document, in the bundle.
There is mails. I don't remember now, but we can pull the document when it's going.
Well, let's just look at 259 again. This is the email from Mark. In the second paragraph here, Mark has mentioned the facade, and he has stated the facade work is still not completed. You are now 10 days behind schedule with this. Mark is not asking you to hold off the facade or redesign it. Mark is saying, why isn't the facade work completed yet?
Can you define what is the facade work?
Well, you seem to know what I was talking about a moment ago when I'm talking about a variation to the facade.
Yeah.
And now I refer this email that was sent as a summary of the discussions that were had on the 10th of November, which you weren't at, but you say that the facade was an issue at that meeting and that it was being varied. But in Mark's summary, the email, the only evidence of we know what happened at that meeting on the 10th of November is that facade was 10 days behind schedule. You agree that what Mark is saying in that email on the 10th of November, that the facade is 10 days behind schedule.
Can you, in the same email, see, the MEP works 50% of the glass window. You know what is the glass window?
I'm just talking about the facade.
This is the facade. There is no any other glass window.
You've noted in your witness statement that facade was an issue. You say that DIF instructed a variation to the facade in that meeting on the 10th, and I'm saying that what Mark wrote contemporaneously after that meeting on the 10th, completely opposed to that.
And in the same email, Mark is talking about a glass window. I'm a layman. We say facade. We should call it facade or a glass window. The facade work, our scope of work is to take off the existing glass and steel work, which we clearly demonstrated in the pictures, which we have submitted through our lawyers. So we have done it already on site. In order for me to fabricate or to proceed with a new fabrication, I need to receive a new agreed design. In terms of demolition, I finished whatever work related to the glass window or the facade.
Right. So do you have your response to this email from Mark that he sent on the 10th of November opposing this comment he's made about the facade? Saying that it's what you've said to me now, that the reason the facade is 10 days behind schedule is because of this reason you've just stated?
Probably did have answered him.
Probably we have no evidence probably that someone else may have responded.
We can put the evidence on front.
Well, you've had that opportunity beforehand. Now, you made your witness statement on the points in relation to this case, and you had the opportunity to produce all the evidence that you wish to rely on back in February, and you produced 2 documents. So the time is up in terms of coming up with new materials. We've already accepted 1 email today, but you can't point to a document in the bundle where you've responded to this to correct this assertion, because the way I read it, Mark is not saying vary the facade. He's saying the facade is late, finish the facade.
But if you have any further communication, Mark is stating that there is a change of the facade. Basically, you're contradicting your statement, because you're claiming that Mark said there is a delay in the facade and we did not answer him, while few days later or 1 month later, Mark himself and his team, and we communicated to him, stating that there is major change in the facade design. It's a fact. I mean, if
It's not made out in your evidence.
sorry?
There's no evidence to that effect. And your evidence is that on the meeting of you say the 11th, but we mean the 10th. The facade, you say that the facade was an issue, variations to the facade was an issue on that meeting, but this email from Mark sent on the 10th contradicts that was a discussion at all at that meeting. I will move forward. I don't think we're getting any further.
I don't know exactly what you're aiming here for, because for me as an engineer, whether he tell me the facade work is not completed within the timeline that we shared with him, and then after a few days he come back and tell me, you know what, put it on hold because I'm changing that design, that does not affect the overall scenario of the project. You are discussing an incident through an email, which I do understand. However, the same client, the same guy, a few days later, he said, put it on hold, I'm rebranding.
So what you're saying is that your witness statement isn't correct. You're saying that this discussion happened on the 10th.
I did not mention
sorry, you
this
said that
in
the
my
information occurred on the 11th. In fact, was a meeting that occurred on the 10th. It was a meeting that you weren't at, and the only minutes that we have for that meeting contradict what you've said. Us at that meeting.
What I have said clearly.
I would like to move forward. I understand what you've said.
Can I just read again clearly 31, because I have not contradicting myself here. I said, Mark has met the IF team. Forgive the date if it's 10 or 11, it's fine. They have discussed the program timeline changes to the approved design by Govin, which is the designer. We have design revision received from Govin and Mark copied in the same email, which is extremely important to explain herein. As I mentioned, the major
stick to the words here. I mean, you're sticking to this, what you've stated here on the 31st. You're saying that this is your rendition of what occurred on that meeting of the 11th. You say 11th or 10th. We all mean the 10th, right? All I'm pointing out to the court is that, in fact, that in reference to that same meeting, Mark took and sent contemporaneous notes that contradict this. Okay.
So just there, for a moment, reached the stage where Ms. Abbas was going to join.
Right.
I just don't want somebody hanging around particularly. I think perhaps we just take 5 minutes while you get in touch with her. And,
okay.
And you'll know how long you're going to be. So
it's taking a little bit longer than I had anticipated.
Yes,
Your Honor.
Well, it has, because you're only scheduled an hour, and we're an hour and a half in. So.
Right. I think maybe 20 minutes, half an hour.
Well, up to you.
Yeah.
I don't particularly want to bring a guillotine down, but I don't equally want to waste Ms. Abbas's time.
Okay.
I'm happy to start her this evening. So let me just rise for 5 minutes while you get in touch with her and see. Alternatively, it is 3:35, 4 o'clock. Starting her at 4 o'clock. I'm happy to sit till 5. How long? Look, Karzal, how long do you think you're going to be with Ms. Abbas? If we started her 4 o'clock, 4:15, would you finish by 5 o'clock? Sorry?
Not be so long.
Will not be so. Okay. Well, in that case, yes. Then maybe we can finish her evidence. Thank you. That's very helpful. Okay, 5 minutes. Get in touch with her and make your peace with her.
Yes. I'll suggest we start about 4:15.
Yes. Okay. So it's 25 to. I'll come back in at 22. You've got 5 minutes. Okay.
Thank you, Your Honour. Sorry to be a stickler. Can Ms. Yogita, I think there's a bit of assistance being provided to the witness by his counsel sitting next to him.
Sorry, what?
I'm just asking if perhaps the client's solicitor could return to the bar table rather than sit with the client.
Okay.
Is that okay?
Yes, I mean, I don't, it's up to you.
I'm sorry, I just think that perhaps the witness should be without someone there providing assistance, or
As long as he's able to
work the bundle. That's okay.
If I need help, I will.
Okay.
All right, but just the top.
Okay.
Of
The other question about Ms. Abbas.
Abbas is Natasha's ready for 4:15. She'll be.
Okay.
Yes.
All right. Well, then you
We'll
better
crack on and
you better crack on.
yes.
Yes. Make sure you're finished by 4:15.
Mr. Fideli, who is Dilip Menon? Dilip Menon.
He's the appointed PM.
Right, so he was the replacement of Yukesh. Okay. And he, again, why is he not a witness in this case? Why is he not a witness in this case?
I have asked, I discussed with Dilip everything, and I have gone through all the emails, all the correspondence. I was copied in every single correspondence, and I understood the history from Dilip, so I thought I would be the one because I was involved with Dilip in everything.
Right, so I just want to turn you to page 340 of the bundle. This is an updated project plan that was sent by Dilip to Mark on the 13th of December 2021. 340. Recognise this document? Yeah. You agree that this document shows that DIF completed the demolition works on the 17th of November and then stopped?
What date is this?
I believe it was sent by Dilip to Mark on the 13th of December 2021.
13th December, okay.
13th December, huh?
Yes. You agree that this document shows that DIF completed the demolition works on the 17th of November and then stopped?
Well, I think it's common ground that work stopped on 17th of November.
Right, but this shows no progress to any works whatsoever from the 17th of November up to 29 November. Agree with that? But this document, does this document say that, or?
This document, part of it related to the old timeline, and the whole document, the whole new document discussing the new agreed timeline. Now we are trying to link an old date to a new proposed date.
I don't quite follow you, but we'll move forward because we're running out of time.
When you say the demolition has finished 17th, yes, I would agree.
Agree with that?
Yeah.
And
However,
then after the 17th, there is no progress of any item of the works on this drawing.
There is lots of progress.
Right.
Sorry, where does this program show progress?
So my reading of this document, Your Honour, is that there is progress with the hoarding works and demolition
No,
works.
where does it show progress? It shows, it's a program.
That's right.
It shows start dates, end dates, and durations. But where does it show progress?
Okay. Now, this is again, Your Honor, I need 10 minutes to explain technically.
No. Just tell me where this shows progress.
Okay. The progress was securing approval.
No. Where does this document show progress?
So,
When we say progress, you're talking about site progress or a project progress?
Any progress. Does this document show, all I want to know
so
is,
my understanding with this document is that it was sent on the 13th of December, and it showed the works. So the lines that had been drawn prior to 13th of December is real progress. That is what had been done. And then there is a gap of nothing further. And then on the 29th, some works resume. And then on the 13th of December, there is essentially planned resumption of multiple items on or about the 13th. And there is a note for payment to be made on the 15th of the 12th, which is in relation to the first progress payment.
Okay, because I just need...
where is all that evidence? Who explains this document?
Well, he is not. He has not been. This document was prepared by the claimant.
I mean, I hear what you tell me. It is not obvious from the document because all I see is a program.
Right. So the details of this and the relevance of this document is set out in the witness statement of Mark Takei. So his evidence in chief explains this.
Okay.
Mr. Fadali, why did the work stop on the 17th of November?
Okay. Good question. The work consists of work was supposed to be done again. Just stating the fact that the work, what's on site is done, and the measure of work is being done outside. The outside work we did not stop, apart from the facade, because there was a change on the design. Everything else needed to be done outside. We were sourcing even material or coordinating with the designer or following the fabrication on the factories. The work on site, what we needed to be done is done to receive the finishes.
Right, so you're saying that the works on site were as complete as they could be?
Yes.
Right, and you didn't stop the works because of the non-payment?
Okay, if I paid to a subcontractor 50% advance payment, the contractor will proceed till he reached to 50% and then he will invoice me, okay? Mark has come twice to the factory to see the production of our joinery and the steel work related to the joinery. I delivered...
Okay, that's in the evidence of Mark. So, and Mark has addressed that in his evidence, and his evidence is that he wasn't impressed with the progress. So we'll move on. The site work stopped on the 17th of November.
Can I ask you something? If Mark said that he's not impressed, that means that this is the truth.
Sorry?
If Mark said, I'm not impressed with the progress of the
I'm summarising entirely. But again, look, you've had the benefit of 80 days of being able to review the claimant's evidence, sat with you for 80 days before you did your witness statement. There's points in Mark's witness statement that you haven't addressed, and you haven't counted any of Mark's evidence in relation to this document, which says that all the work stopped on the 17th of November. Now, on the 29th of November, there is a resumption of some works, and then the majority of works recommence or were planned to recommence on the 13th of December, which is the day that this document was sent. And now what you've said is that the works on site stopped because they were as complete as they could be. There was nothing more you could do on site. It wasn't related to the non-payment of the work. Because the work stopped on the 17th of November. Sorry, I interrupted you. If it's a yes or no answer, you
mean to say that we stopped working?
17th of November.
Let me cut through.
Right, thank you.
It seems to be agreed by everybody that you stopped working on the 17th of November on site. That's an agreed fact. That's what I'm told. Okay? Why did you stop on the 17th of November?
Okay. When you ask a contractor, we finished a stage of work that it's supposed to receive a new stage of work is being fabricated outside.
So you finished, you're telling me that by the 17th of November, you finished all the work on site to be completed before you bring in the fabricated units from off-site.
I would love to explain to Your Honor something.
We don't have the time. We'll move on.
If I'm putting a cladding wood,
Yes,
there is a surface below.
I know that. You put battens, and I know how it's done. Okay. And you have your first fix electricals, you put it up. Your second fix electrical. I have done construction cases for 40 years. I know.
Thank God. So,
okay.
Yeah.
Mr. Fadali, you've said it in paragraph 30, and you have a list of dot points in relation to the works that you had done up to the 17th of November. And you talk about removal, regarding ceramic works. The friend has lost one. No problem, we'll skip forward. Okay. Now, the matters we've talked about this 10 November meeting a lot. In that 10 November meeting, that meeting was called because Mark was concerned about the level of progress. Does Mark's concerns about the level of progress align with what is set out in this document at page 340? Because as we've talked about the original program, which is at page 247 of the bundle, the demolition works were due to have been completed by the 8th of November, yet this drawing on page 340 shows that at the 8th of November, the demolition works were barely a third of the way through, and they weren't finished until the 17th. So did Mark have good reason to be concerned on the 10th when he called that meeting, concerned that the works were behind schedule? And this is in light of you saying that you agreeing that the 31st December deadline was a tough target. It was 60 days. The parties had to work quickly to achieve that. So did Mark, I'll rephrase the question, do you think that Mark had good reason to be concerned on the 10th of November about the progress of the works?
No. Because, can I give reasons?
Well,
because they were
no, I guess that's your opinion, but the fact is that the original plan said
change in the design.
The original plan said the works would be completed by the 7th, by the 4th, and now they're not completed until the 17th. So
again, Mr. Glenn, if you come and tell me I'm late in this item, but you are changing the design and you're not confirming.
We're talking about the demolition only. Demolition was still being carried out on the 10th, 11th, 12th, 13th, 14th, 15th, and 16th.
Here is the concern, whether we accept the concern or no.
All right, but I'll move on. Mr. Fadali, during this session, we've talked a lot about the site. We've talked about on-site and off-site. And not once was there any confusion about the meaning of the word site or the meaning of on-site and off-site. You've been very clear in your witness statement about works that were done on-site and denoted other works that were done off-site. You've stated at paragraph 34 of your witness statement, and I quote, "Yes, the site progress was not impressive, but due to the fact that the majority of works was off-site. Do you agree that the works done at the cafe were site works?"
Sorry?
The works done at the cafe were the site works.
The work done at the cafe? Yes. Okay. In my...
So yes or no? When we talk about site works, are we talking about
I talk about,
works
when you
on
tell
the
me site work, I talk about a project. This is the site works. It's a project. You cannot... It's like a human being.
So you are talking in your witness statement with clear definitions of on-site, off-site, but in terms of that use in a contract, the terms off-site and the term on-site has no functional difference between off-site works. Is that your position?
It is one work. On-site, off-site, it completing the whole project. If I'm contracted today to supply and installation this hall without supplying the furniture, I did not finish my task. Even if I'm claiming money, I have to finish 100%. So a contractor look to a project as on-site and off-site. Why? Because it's custom-made, specifically material to this site. It is not to the other side.
Thank you. I agree. But so you've pointed out that there is a distinction between works done on-site and works done off-site.
There's a definition. I'm defining only.
Correct. I agree. I
Differentiating.
also agree that there is a differentiation between on-site and off-site. So we are agreed on that. The Fidalia RAFID to page 23 of the bundle.
23.
Page 23, yes. This document is provided by your own auditors, and it states that the value of the work executed at site was 109,055 dirhams. It also states that the value of materials on site is nil. Do you agree with that?
Material on site.
No, well, just the statement that is in that
this,
document.
That's what
you're good.
This is what he wrote.
That's what he wrote, correct. Now, Mr. Fideli, I refer you back to paragraph 8 of your witness statement and note again that your own testimony clearly states that the first progress payment was payable against 30% site works progress.
Okay.
I'm sorry, I've skipped back and forth here. I'll continue on with the matter of the 109,000 assessment by Mr. Kudapan in his report. If we do the maths, 109,000 dirhams of work is just 12.8% of the contract.
12.8% of the price of the contract.
Correct.
Not necessarily 12 point whatever percent it is.
Right.
Work. Depends how you define work, whether by value or...
I believe in this case that's the way that it was done. There's no suggestion otherwise that any other method was used to calculate the value of the progress, and there's no evidence by the other side to that effect. And in fact, the calculation of the 54% completion was, again, purely based on the values of the amounts claimed.
Okay.
Yep.
So,
Mr. Fideli, I understand your position is that DIF achieved over 50% progress of the works. Is this still your position today?
Written in my statement.
54%. This is yes.
Yes, as a contractors, as an entity, we evaluated the work 54%.
that's 54% by value.
By
progress.
By progress. Our progress is 54%.
Yes, but how do you assess progress?
The way we assess progress, we go into the BOQ against every line item. We put a progress, and this progress define a value.
Yes, but how do you define the progress in relation to the BOQ item?
Have quantity surveyors. They go for evaluation.
So that it's progress by value or progress by completion?
By completion.
And how's that measured? So for example, if you're painting a wall, does somebody come along and measure how much of the wall has been painted? So actually they come along and physically measure?
They are surveyors, quantity surveyors.
Okay.
Unless, can I clarify as a matter of honesty? If I'm contracted to fabricate this counter and I invite you to come to the factory and you see the counter without painting, I put a claim because if I just paint it, spray paint it, this is veneer on a spray paint, lacquer, clear paint. If I spray it and I wrap it, it will be ready to put on site. So until the factory visit, when you come, we consider as a common practice, this is maybe 75 to 80% because it's just painting, wrapping it and deliver it to site. As long as you come and see it in my factory, it means I finished as a contract.
No, I understand. All right, carry on, Mr. Moore.
Okay. I'd like to take you a look at how you reached that assessment. Firstly, Mr. Fidelity, do you see that concede that the calculation DIF set out in the progress payment claim includes both site works progress and off-site progress?
Are we still on page 23?
Sorry, Your Honour, which...
Are we still on page 23?
Where that's... No, Your Honour, sorry, we've referring to the progress payment claim, which is a document where 54% was...
Yes, I know that document, that's why I asked. So which page are you on?
Statement of Sharif Adali. This BOQ starts 844.
Okay.
And they've got 50. It's 855, which is the summary of everything.
Yes, I've got that. Yes, I'm familiar with that. Okay. Better crack on.
Yes, I'm sorry. I've just been lost in my page. You stated in paragraph 32 that you believe the reason why RAFID Gourmet wouldn't pay you the first progressive payment claim was because RAFID Gourmet was forcing DIF to invest in OPSO. You go on to say, and I quote, "I've called Mark at the time and informed him that Faisal is waiting to... if Faisal is waiting to see joinery items reaching the site or facade works being installed, then he would release the funds. This would not be achievable. All suppliers will not release any items from their factories unless we pay them the first progressive payment in addition to the received advance. In my understanding of is my understanding of this statement correct?
Page number?
This is in your witness statement, paragraph 32. I don't have the page number.
Yeah. Okay, I got it.
Okay. Is my understanding of this statement correct? You are saying we can't progress the works unless we get the next payment. For example, with the joinery, you are saying if RAFID Gourmet pays us, we will pay the joinery contractor. He will finish the joinery works and deliver them to the site. But we won't pay the joinery supplier unless RAFID Gourmet pays us first. Is this roughly the correct summary of that statement? And is this your stance? Yes or no?
Yeah, it is.
Yes. Okay.
Because at that progress was over 70%. 70% on the off-site item, which I need to pay the suppliers to release it and deliver it to site. And
so this is why the works came to a halt, because of the second payment.
And there is an email in our pleadings. The word on-site came from Mark. It did not come from our understanding. When you say site works, it's a whole project progress. The point of enforcing us to accept on-site material delivery, on-site material, that was not the idea of us at all. That it has been enforced, and we have mails in the pleadings from Mark saying that this is our Saudi company policy. So, again.
Okay, we've covered this, and we'll continue on. I would just like to ask you, where in the contract does it provide the works carried out by a subcontractor that are part paid and part done by that third party, entirely off-site, count towards site works progress? Does the contract provide for this? Is that stated anywhere in terms of how the site progress is?
In this particular project or in the industry?
This project, this contract, this document that's all we have. Document that says progress payment against site works progress.
My answer, it will fall in the construction industry.
Okay, that's not the question though. We're talking about the contract.
No, this is the...
No, but he's saying you've got to understand it in the context of custom and practice in the construction industry. That's your answer. Your answer is that as far as you're concerned, when I come to interpret this contract, I have to consider not the precise wording of this contract, but custom and practice, which when you say site progress, it includes on-site and off-site. That's your case? Yes. Yeah, okay. All right, I understand the issue.
Mr. Fideli, let's look at the situation with the furniture a little bit. This is the biggest ticket item. It accounts for more than 28% of the value of the project, and you have claimed most of the amount as effective progress of the works and counted it towards the works progress. So of the 239,000 dirhams payable for this part of the works, DIF claimed an entitlement of 209,000. That's 100% for every single item of loose furniture except one item, of which you have claimed 50% for.
Correct, because it came to Dubai on my personal...
Okay, so we'll forget about the one item. Let's talk about the bulk of it. It's just 209,000.
Can I explain myself, please?
Had DIF paid for this?
Left Greece.
We're asking
on
questions.
My personal promise to my subcontractor, it should not leave Greece without payment. I called the subcontractor and I said, on my relationship, please ship it to here, to Dubai. The subcontractor shipped the whole material to Dubai without me paying.
I appreciate
the other
that.
50% of my contract.
No, I understand that. We have to be quick.
Yeah.
Okay.
It's fine.
Had DIF paid for the furniture in full?
50% of the
50%. Did you have fire rating certificates for each item of the furniture? Yes or no?
We have given it in a later
yes
stage
or no?
when we requested.
So what certificates? I didn't catch that.
The fire rating certificates, documents required to ensure that the furniture is suitable for the premises.
Based on
So you say fire?
Fire rating certificates.
Fire rating, okay.
Yes.
I urge you to read the Dubai Tenant Manual, the Tenant Manual of A'mar.
Okay.
There is no way they mention fire-rated certificates to be supplied on furniture. This request, I have been asked to supply a Louis Vuitton bag. I went to Louis Vuitton.
This is not relevant, please.
Can I continue?
No. Talking about a Louis Vuitton bag is not relevant.
I purchased the Louis Vuitton
I will
bag.
continue on.
Let's leave Louis Vuitton out of it.
Okay.
And so did they have, the answer is, did they have fire?
They had and we submitted.
You submitted?
Submitted.
Okay,
Yeah.
right, so your answer
Okay.
is we submitted for them.
Had you delivered such items to the site free of defects? You've claimed 100% payment. Were any of these items delivered to the site?
No, he said that they weren't. He said that
Correct,
they're stored.
okay.
You're asking questions that we know the answers to.
Okay. My apologies, Your Honour.
Well, it's your dollar, as it were, you're on. So I'm just trying to help.
Yes, please. Thank you. Was RAFID Gourmet entitled to go to the furniture supplier's warehouse and take this furniture?
Because I agreed.
No. Was it? Could it, at this time when you've submitted the payment and you've said 100% progress, could they go and pick up the furniture?
No, they don't have LPO. They don't have purchase order with the supplier.
No.
It is my order.
Correct.
I
Nobody
agreed
could
verbally.
remove those goods from the site until they were paid for.
Exactly. Your contract, it's your contract with the supplier.
But I agreed as a matter of good faith and good intention.
That's all different, but I mean, I'm just interested in the contract, and I understand they're your supplier. This is you contracted to supply the furniture as far as the client is concerned.
Mm-hmm.
So again, not massively helpful.
My point is, Your Honour, they've claimed 100%, yet they cannot remove...
I've got
okay,
the point.
good. All right. Mr. Fideli, you've stated at paragraph 45, on 8 December, DIF has received email from Faisal requesting again the workflow schedule and the new handover date, and stated that he agreed now to pay outstanding payment to DIF. Ref mail dated 8 December received from Faisal. Mr. Fadali, can you please show me a copy of this email?
Where are you looking at? Sorry.
Paragraph 45 of the witness statement.
Okay, got that.
Yeah, sorry.
I have shared it with my lawyers. I have shared the email from.
Okay, but it's not attached to the witness statement, correct?
No, it's not attached.
Okay. Mr. Fadali, at paragraph 47, the targeted handover date of 15 January, RG has agreed to a new payment term not related to the site progress but based on overall works done. Attached mail received from Mark dated 11 December 2021. Mr. Fadali, again, can you provide me or point me to the court bundle where this email is
provided to the lawyers, and we can.
Not in the court bundle.
It's not in my. I did not attach it to the statement, but I
have no further questions, Your Honour. Thank you, Mr. Fadali.
So, Mr. Kazel, do you wish to re-examine the witness?
Yes.
Yes, of course.
Sharif, your witness statement, you guys hold one thing I want to point out, which
That's not re-examination.
the question is the following.
In the payment certificate, yes.
Exactly. So, someone from the RAFID GOURMET discussed in details this, or we have to wait till Natasha Abbas is appointed in December. Yes. So, they take lengthy time not to pay you for over 20. Natasha came and then she reassessed everything. Yes. Where you were kicked off. Yes. Common to say that you stopped the work because you didn't get paid, but you continue your factory works and all this stuff, and you paid from your own pocket, right? Yes. Second, second question. When you were exchanging with Mark, as you said, regarding the boarding, that your responsibility to do the hoarding or Amar to do it? My question is because in your testimony, there is a invoice of 27,000 dirham on hoarding, so that you made extra, because this should be on Amar's side. Yes. And this hasn't been taken into account with Mrs. Abbas too, while she should be.
No, I accept, Mr. Bull, that none of this is proper re-examination. These are leading questions. You can't put leading questions in the examination. I am ignoring the evidence at the moment until you put a proper question in re-examination. Re-examination is examination that arises solely out of cross-examination and has to be non-leading. So far, you've made 2 speeches and you've asked whether he agrees with this or not. That is not re-examination.
Your Honor, can I reformulate the question?
Of course you must, otherwise I will keep on ignoring the evidence you're trying to adduce.
Hoarding works is part of your works, yes or no?
The external, no. The internal, yes. The external hoarding work should be done by the mall contractor. We are not allowed to do it. We have done the internal because it's inside the demise line of the shop.
As of the 30th of November, when you issued the invoice, demolition work have been done on your side in the shop, yes or no?
Yes.
Totally. You consider that the loose furniture that you referred to in your statement is part of the inside work, yes or no?
Definitely, it's part of the project.
Can you elaborate?
It is customized for this project. It is custom-made items for this. I cannot sell it to anyone else. It has to be inside the OPSO project. So our evaluation, it's an expenditure. We spend on it. We spend money on it. So it's fall on a part of the project. I cannot just say it's excluded and included. It reflects a value.
Out of the invoice you have issued, number 63, more than 30%, according to your interpretation, that has been done inside progress work.
Sorry, do carry on.
Out of the invoice you have sent on November 30th, you consider that more than 30% of the inside work in progress has been achieved? Anybody after that date, before Mrs. Abbas came, discuss this invoice with you? Nobody discussed it. The only response is not to pay.
That's it. Thank you very much. Perfect timing. Thank you very much. Thank you very much. I'm sorry that we've been strict on time, but I do understand everything you said.
I can come anytime because I really need to explain construction to. I'm an architect. My mother, she's an architect. My wife, she's an architect. So
thank you. I do have some understanding of construction, so I think you're okay there.
It's a human being for us. A
Yes.
project is a human being. You cannot say this is in, this is out.
I understand what you mean. Anyway, thank you very much for your evidence. We have to take the next witness now, who's joining us remotely, so that's why we are on timing. So let's deal with that then, shall we?
Ms. Abbas, can you hear us okay?
Yes.
Would you allow me to swear her?
Yeah, I would like, I'm not sure I have her on screen. Yes, I do. Fantastic. Yes, please, would you swear the witness?
Ms. Natasha, please provide us with your full name and occupation for the record.
Please provide, sorry, what?
I'm sorry, would you please state your full name and occupation for the record?
I'm Natasha Ahmed Abbas, and I'm a project manager, a civil engineer by background.
Thank you. And will you be affirming or swearing in today?
Affirming.
Affirming. Please repeat after me. I solemnly declare and affirm.
I solemnly declare and affirm
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you. Thank you, Natasha.
Yeah. Before we commence, I'd just like to explain that I did write to the court requesting to be exempted from this from the witness statements because of conflict of interest. But I understand that we were asked to nevertheless appear and provide witness statement. We have a conflict of interest with the client.
Right. I will
Can
just
I
explain.
please? I'm aware of this. Let me tell you what the position is.
Yes.
There is no such thing as a conflict of interest between a witness of fact and a party, because all you have to do is tell the truth.
That's right.
Telling the truth can never give rise to a conflict of interest.
No,
so
I thought.
Just here to tell me. You're just here to tell me what you remember as true. That's it. No more, no less. Your relationship with anybody else is not important, because the truth is the truth, no matter what your relationship is with anybody else. So don't worry about that. You just tell me, you give me your evidence as to what you did, what you saw, what you found at the time you're going to be asked about. That's all we're interested in. Okay, is that fine?
I just thought, yeah, that's fine. That's why I affirmed, and I just thought it's necessary for me to inform the court that we have a case against the client in the small claims. It may or may not be relevant. Yeah.
It is completely irrelevant.
Okay.
And as I say, all I want from you is your truthful recollection, nothing else. All right?
Sure. Sure.
Thank you.
Thank you, Natasha. Natasha, I refer to, do you have a copy of the witness statement that we prepared and that I sent to you on the 6th of
Yes, I've got it on my
July,
screen.
just in preparation. Yes, and so it has some red numbers in the top right-hand corner. Is that, you can see that?
Somewhat, sorry?
A number in red at the top, starting from 469 and continuing.
Just bear with me a second.
Otherwise, if you have your original version, it may just be page 15 of the document.
Page 15 of the document that I have has no numbers on it. It's just got my signature and the date of the 6th of February 2023.
Perfect. This is the exact page I wanted to bring you to. Natasha, I just wanted to bring you to this page and confirm that this is your signature, and
That's right.
that this document was made under the statement of truth, which is noted just above, on the 6th of February 2023.
That's right.
Natasha, have you had an opportunity to review this document to refresh your memory since the 6th of February?
Yes, I have today. I've looked at it.
Yes. Is there anything you wish to change in this document now before we submit this document as evidence?
No, I have nothing to change. I did see the skeleton document that was provided by the defendant, and there are some corrections
Don't worry about that.
Okay.
Yeah, correct. Yeah, no, that's, you don't need to speak to the truth of that document, but just in terms of your document, you're comfortable with everything that you stated in this witness statement?
That's right, yes.
Your Honour, I tendered this witness statement of Natasha Abbas as evidence in this case.
Thank you. Ms. Abbas, you're now going to be asked a few questions by Mr. Mukarazel.
Abbas, I just want to start with what has been written in your witness statement. As I understood well from your statement on paragraph 17, that you started your work on this project on December 20th, 2021. This was your first kick-off meeting with the IF team, right?
No, I started work on the project when we were appointed on the project. So that was the 15th of December.
15th of December, but you met first the IF people on 20th, right?
Yes, after we got appointed and we got signed up and appointed as per in line with our contract. Thereafter, the first step was to meet with the team.
So at that time, the work was obviously stopped at the shop, right? Because
that's right. At the time, there was no works happening at the time on the shop.
Great. So you never had any opportunity to supervise or control any work on progress?
No, I never saw anybody at site.
Obviously, yeah. If you start on December, so if the stop on November. So
but the works were stopped. The works were stopped in December, and that's why we were brought in to help kickstart the works and get the project back on track.
Exactly. So then you start your job as kind of a mitigator, as I understood from your witness statement, to check, one, if there is any obligation to the claimant to pay the second payment. A second, as a mediator, to try to reconcile, if any, the two positions in order to deblock the situation, right?
No. It was to get the project back on track. So in December, when we were appointed, the client's intention was, when I refer to the client, I mean the claimant. The intention was to get the project back on track and give DIF the support they need to get the project up and running. There were blockages on the project prior to us coming on board. And the reason for us being on board was to get the project off the ground again, get it moving. It had stopped. It wasn't to mitigate, it was to project manage the project.
Sure, but in order to put it on track again, as I understood, there is a firm claim from DIF that the second payment is not yet released unlawfully and illegally or contrary to what they agreed. So if you start your job is to assess the work of DIF, whether or no DIF is entitled to be paid on the second payment or not.
No, that's incorrect. Right. Our job was to start off with, it was to understand the status of the project, keeping aside the commercial matters. It's the actual progress on site. What are the issues? What are the design comments made by EMAR? What are the changes that are necessary to be undertaken in order to move the project forward? So it wasn't to purely assess claim and monies. It was to get the project moving, to understand what are the blockers on the project in terms of design approvals from EMAR, in terms of addressing EMAR comments on the shopfront facade, in terms of the signage. So there was a set of EMAR approved drawings with EMAR comments, one of them being a blue LED light that was rejected by EMAR. So it was to understand all these blockages, get the design approved and get the works moving. It was never to just come in and assess the commercial claim for which the works had stopped.
If I refer to your statement again, there is a major part in terms of figures related to the progressive payment claim, and whereby you put in columns what is claimed, what is valued, and what is determined.
That is after the kickoff meeting that was held in December itself. It is after the kickoff meeting where DIF were requested to give certain to have certain deliverables in terms of giving the most up-to-date program that they'd be working to. There were a few items that DIF had to complete in order to get us moving. And this assessment only happened after the meeting.
Okay, so during all this progress meeting, DIF was present with you in assessment?
Yes, this was the first kickoff meeting. For which we minuted the minutes, and we circulated it for everybody with actions and deliverables and timeline by when they should be giving us the program, the next steps, the revised drawings, all of that. So this is part of one of the, I think, annexes to my statement, where there's a meeting minutes that was issued, and the assessment followed only after the meeting minutes and after the kickoff meeting.
How many meetings you did with DIF?
We did the first kickoff meeting, and then they failed to deliver after a week, and then we kept chasing them, kept calling, and then we had another. We didn't have any further progress meeting. There was one meeting held for which we did not issue minutes because it was irrelevant, because tempers were flying across the room and both parties were accusing each other. So there's no point in minuting something that has no actions and no deliverables. So that was the second meeting that everybody attended, and it was just purely to discuss commercials, and it turned into a finger-pointing, blaming match between the two parties, and we did not issue any minutes for that.
So if I understand you well, and according to what you said and your statement, the assessment of the works that you integrated in your statement is based on one kickoff meeting, and then from all the documentation you get from the claimant.
No, my assessment is based on site inspection. Site inspection.
With the presence of the
if you look at the kickoff meeting minutes, it clearly states all the deliverables. And if the deliverables weren't delivered, then that is a separate action list for us as project managers to follow up. A commercial assessment is never based on project kickoff meeting minutes. It's based on on-site progress.
Okay, so back to your assessment. Could you please explain to me when you itemized the work A, B, C, D, E, F, you said claim completed is what is claimed by the defendant, and then you said value claimed, so you value the amount of work, and then on the value determined, what is this numbers, which is almost zero. This is what you assessed?
Yes. Because the temporary hoarding, the temporary hoarding, if I go line item by line item, the temporary hoarding, there were two bits of hoarding. There was one internal hoarding, which was done by DIF along with the digital screens, and there was an external hoarding for which the client paid the monies themselves. And that is standard EMAR mode procedure. Contractors don't pay for hoarding. It is the client that pays, but DIF were claiming an amount for that hoarding.
Okay, but what I'm just a bit surprised because there is a big discrepancy between what the DIF is saying and what you ended up, because look at the demolition works, and I know from my clients that they did almost all works of demolition, which is claimed at 100%, but you measure it and you value it at 2,000, right? While for them it's 20,000. I mean, did you try to reconcile between these two figures with the client, with my client at least, on the site when you
this assessment was given to our client, RAFID GOURMET, and it was up to the client's discretion whether or not to share it with DIF. So this assessment was not shared with DIF by us.
For any reason why you didn't?
We were awaiting client instruction to share it. We did not share it. We have to go through client approvals and then share the valuation.
So this was a client decision not to share it.
Yes, they said they would review it. So they would review it internally, and then they would share that. Then they would instruct us to share it.
I'm asking you this question, Mrs. Abbas, because what is written in your report is not only different from my client assessment, but different from Mr. Saraga assessment too, which you met many times, I guess, according to his statement. You did not try to reconcile the figures between you and
until I have instruction from our client to. Until I have instruction from our client to discuss commercials with the contractor, I'm not entitled to do that. It's as part of our contract as well. It says that North 51 have no, in the last paragraph of our contract, North 51 have no legal authority to sign off commercial expenditure. If you go to the last page of our signed consultancy agreement, we bear no legal, we don't do design, and we don't have any authority to sign off commercial expenditure. We can recommend, but we can't sign off. That's just company policy.
You were acting as a project manager, right?
Yes.
I mean, you were acting as a project manager, not only consultant or expert.
Project consultant. Project managers are consultants.
Both. So you confirm to me that this report has been made unilaterally without discussing it with my client, or without sharing any.
It may. I'm not sure. I'm not sure if our client shared it with the DIF, but we did not issue this to DIF. I can't remember if we issued it to DIF. I'm quite certain that we didn't.
But from your side, you conduct all this job unilaterally with one kickoff meeting with the client, and then you make your report for your own without discussing.
One kickoff meeting with the client and the contractor, not just the client, for the record. One kickoff meeting, but this assessment, again, I am obliged to point out that this assessment is done based on physical inspection of the site. It has nothing to do with a meeting. A meeting is held on a table with 4 chairs. It has nothing to do with the meeting. It has to do with site inspection. An actual look, you have to monitor it and you have to see the progress on site. If the tiles are delivered to site, you award money for the tile. It's supply and install. I can't just award 100% for supply and install of tiles when they haven't been installed and only supplied. That's just one example. But the hoarding, the hoarding was the external hoarding was paid by the claimant, whereas the internal hoarding works were done. The site was internally hoarded up with all the digital screens installed, with power to the digital screens installed, with the curtain installed by DIF.
Yeah, but the hoarding made by the client, did you mention it in your report? Because I'm not seeing the amount. I'm seeing
The
that
hoarding.
this is Amar responsibility. Then you value it at 0, and you
No, it's not EMAR
responsibility.
It's not EMAR responsibility. It is EMAR process and protocol in all EMAR malls that there is one company that is allowed to do the hoarding, and that those works are always paid by the client or the tenant in all fit-out projects, be it retail, be it F&B, any projects.
Yeah, sure, but I couldn't see if I refer to your statement in paragraph 29 regarding the hoarding. You mentioned temporary hoarding phase 1. So it's claimed by my client 100% now that we can interpret your columns. It's valued to 7,800, the phase 1, and then 0 regarding your valuation. And you comment on this side, the hoarding was completed, but at the standard practice in all Amar malls, the hoarding was to be done by Amar subcontractor and paid for by the tenant. Fit-out contractors would not normally include this in their BOQ, and they do not perform these works. But as you said, and as we know, as a matter of fact, that the client performed some hoarding amounting to 22,000, 27,000.
Yes.
I don't have the figure in mind.
So
but you didn't figure it out in your report.
No, I didn't.
Now you are telling me there is 2 hoarding works, one made by the DIF, but why you didn't mention the DIF hoarding works?
We did not realize that it was a temporary hoarding already paid for by DIF, and there was lots of emails between the claimant, between Shadi Magdasi, to understand which hoarding is everybody on about, and it was the external hoarding later on that they were on about.
So this should be amended accordingly.
Yes.
Because there is a certain amount made by the client that should be accounted for.
Yes. So this 27,000, if this is in relation specifically to the internal hoarding, then this should be awarded to the contractor.
Okay.
Sorry, just so I'm clear, are you saying then that items A1 to 5 there were actually performed by DIF? Is that right?
Yes. If it's referring to the internal hoarding, then yes, they were performed by DIF.
Okay, so then you would accept the 27,200 is payable?
Yes.
Yes. Okay. Excellent. Thank you.
Yes, Mrs. Abbas, going back to the demolition works, because there is a big differences. We're lost a little bit. I am lost at least, because my client is determined that he made this demolition works as of the 17th of November. This has been done. The report from Mr. Sagaya confirms this demolition works, but when it comes to your report and your assessment, it seems that little or few has been done on this side. How can you explain this difference between you and my client and Sagaya that you met many times? And my second question to be,
I don't recall.
Align your position with Mrs. Sagaya?
I do not recall. Sorry, who is Mr. Sagaya?
The one from Good Faith.
I've never met him.
He tried to reach you.
He may have reached.
He tried to reach you, and one of his team maybe met.
Sorry, just speak another time. Sorry, Ms. Abbas, please speak.
Okay. I have never met Mr. Sagaya. I have never met anybody from Good Faith. I received an email from Mr. Sagaya, and when I read the email, I picked that he was an auditor, and I asked for DIF, outsourced externally. So I raised it up with our client and explained to our client that, are you okay with us writing back? Because we need authorization. I can't speak to anybody without authorization. So we need authorization from DIF stating that, yes, they have appointed Mr. Sagaya in relation to this project. And once we received that email confirmation, it's only then that I communicated by email with Mr. Sagaya. I've never met him. I don't know what he looks like. I've never met him on site, never met him.
And so you didn't receive any email introducing Mr. Sagaya from the IF to you?
No, I received an email as authorization later.
When later?
The first time Mr. Sagaya, yes, the first time Mr. Sagaya emailed me, we acknowledged his email, but we said, please provide us evidence that you are authorized to speak on behalf of DIF. And once they did, we communicated with them. But it was very brief. I can't recall the nature of the communication with Mr. Sagaya. It was very brief because all of a sudden he dropped off. So we stopped receiving any emails. We stopped communicating. There was nothing to communicate.
Okay, Mrs. Abbas, if we go back to your statement and your progressive payment claim, so besides the hoarding claim, which we have to readdress, I refer to the part B regarding the demolitions that you said that few has been done. Out of the 20,000, you value only 2,000. And you said that you did not have the opportunity nor the authorization to discuss matter with the IF. If I pass to the floor finishes, to part C, my client was assessing 80% completion, while you value at 1,168, which and so on the wall furnitures, 40% you assess it 0, ceiling wood planks 0, then joinery. I'm wondering, but because there is mere evidence that the joinery has been, produced and work started from the client side, and he valued at 50% completion. So you didn't give any amount of completion. Okay, so this is clear that it's what you said and what my client is claiming. My question is, when you served, because it was you who served the termination notice, right? As I read it in your witness statement.
Sorry,
yes,
Mr.
my question.
Your Honor, we've just had a 5-minute discussion on the assessment without a question.
I'm questioning now.
He's taking a long run at the wickets. Don't worry.
Okay. All right. I'm lost, and I'm concerned that my witnesses.
Just relax.
I'm just analyzing the statement.
Yes.
No, based on your termination notice served to the client, to the IF, did not think before serving this notice to reach out and to try to remedy on this matter?
That's the meeting I referred to, where they all had a slinging match, one against the other. So we did reach out and we did sit around a table, and it was all heated. Neither party was willing to, DIF weren't willing to finish the works, and the client wasn't willing to pay in advance of the works being done. So what happens on normal projects is that once you sign a contract, you give whatever the advance payment is agreed between the parties. The client has to pay the contractor the advance payment so that it can cash flow the project and buy the materials and procure all the items that they need to start. Once that advance payment has finished, once the contractor finishes the advance payment, he demonstrates progress ahead of the advance payment. So if advance payment was paid at 30%, for the next progress payment, the contractor has to have made progress at site ahead more than the advance payment, at least at 40%, 50% as a recoverable of the advance payment. So in this instance, the works, the advance payment that was given by the client to the contractor, part of it was for the joinery works, and this is prior to us coming onto the project. So there's a breakdown where a lot of the advance payment was made towards furniture, towards joinery, towards placement of orders. We're not disputing that. What we're disputing is the actual work on site progress. Demolition works claimed at 100%, whereas the water fountain, you can't pay monies towards non-conforming, you can't recommend payment on non-conforming works. So once they demolished the water fountain, which was within the scope, the amount claimed of 100% was unacceptable because it was a non-conforming works. There was backflow into the existing operational kitchen, which becomes a hazard in food and beverage environment. So therefore, we acknowledged some of the works done, some of the demolition done, and for that we awarded 2,000 dirhams rather than the entire amount because of the non-conforming works. We're not able to recommend anything further on the demolition. Then if I may go down to item C on the floor finishes, value claimed is 80%, whereas the value is 4,240. We determined it at 1,100 for the supply only. By the time the contractor needs to install these tiles, the floor tiles, you have to have the floor cleared up, you have to have screeding, self-leveling or glue, or the price that's 100% is for supply and installed with the grouting. It's not just for supplying tiles and keeping boxes of tiles on site. So that's with the floor finishes. So we acknowledge that these tile boxes were on site and it can be seen in the photographic evidence along with our witness statement, but the flooring was not installed. The existing flooring wasn't removed in quite a few areas as well. Then if I move on to item D, wall cladding, supply and installation of wall cladding as per the approved drawings. There was a huge back of house cabinetry joinery works. Nothing was removed from there. There were just some simple yellow stickers, sticky notes put on there just to mark up which cabinet fascia is being changed and which one's being kept. And that was the only works done. We did not see anything further done to that cabinetry wall. So there's no payment towards it. And this is both on-site and off-site. Ceiling wood planks, there were 2 wood planks that were removed to access the MEP services above and to draw in some wires down to the first fix of the electrical. So for that, the whole wood plank was still the same. There was no painting done, there was nothing done. And there were no materials related to that on the site. So as a result, it's valued at 0. And then you have the signages, you have the retail branding. We didn't see any of these. All we saw was photographs and videos showing minimal progress, and this was taken by Mark. And Mark visited the site, the factory, the joinery factory, not Interior 360 Furniture Factory. He visited the joinery factory and took videos and photographs, and his assessment of that was that they were not fit for purpose because they were not placed in a controlled environment. He saw them in a yard, in a backyard of a factory, and he believed that it was not fit for purpose because it was in an uncontrolled environment. From the videos and photographs, it's hard to tell whether they were or they weren't fit for purpose, but from Mark's assessment of it, when he went there physically, he believed that it was not fit for purpose. With regards to the furniture, I understand that the client had given the contractor X amount of money for the furniture. We did a site inspection of the furniture at Interior 360's warehouse, and we saw the furniture. Some of it wasn't as per the specifications in the drawings produced by 2106. We requested 2106 to come to site, come to the furniture factory, Interior 360's furniture factory, to because they're the lead designers on it, to come and verify that yes, whether this is acceptable from a design standpoint or unacceptable. And 2106, the designers said that they weren't appointed by the client for undertaking any such services, so they would not attend. So we did a physical inspection, took photographs, recorded the number of tables, and there was one type of chair that was missing, one type of table or chair that hadn't been procured, and for that we valued it at 0. But at the time we were told item H11, 15 lounge chairs, they weren't procured. There was not even a single chair of that on site, so we couldn't recommend any payment towards it. And the rest of the furniture, some of them were there, and some of them weren't, and were not conforming to the design. And we're not designers on the project to verify and sign off design. So as a result, we valued it at 0. But after this inspection, Interior 360 and DIF did provide us with the fire retardancy certificates, or the fire certificates that are required by EMAR molds. It's clearly stated in all their drawing packs that all material should be fire rated with certificates, and DIF and Interior 360 provided that to the client. And Interior 360 being a furniture firm, they do not deliver furniture, and this is not the only project. We've worked with them on different projects in F&B in Dubai, and with all furniture companies, when you deliver, payment has to be released prior to the delivery of the goods. Full payment. They will not deliver and release their furniture without full payment. So this is the disputed item between the client and the contractor, that the furniture company sourced to do these works requires full payment. The client probably believes that they don't need to pay the full payment. So this was prior to us coming onto the project, where the orders were placed, where the contracts were done, subcontracted for the Interior 360 to do the furniture. So what ended up happening was that the contractor paid from the advance payment monies towards the furniture, and then the balance that was outstanding was settled by the client way after into the project. So he wanted the chairs for the restaurant, for the coffee shop opening, so he settled it directly with Interior 360. And with regards to all the lights, we saw no lights on site. There was no lights. There was no boxes of lights. There was nothing. So even if there were boxes on site of light fittings, physical light fittings, which becomes the client's possession, we could have awarded monies, but there weren't any boxes of lights. And 50% claiming it's not right. But I would at this instance, given the short fast track project that this was supposed to be, cash flow is very, very critical to a contractor. We're cognizant of that fact, that cash flow becomes very critical on very short programs because of the procurement that needs to happen, and payments need to be paid by the contractor to physically get, and suppliers for light fittings, furniture, they all require full 100% payment before they can release the goods. This is standard industry practice. So with DIF asking for 50%, we are not privy to the discussion between DIF and RAFID GOURMET on the contract advance payment, and what was, if there was anything said verbally and agreed verbally between the parties, we are not privy to it. This I have to highlight. So we go by the BOQ that was signed between the two parties, and that formed the basis of the contract. It was a very loosely worded contract, and we tried to get the project back on track. Whatever verbal discussions or assurances that were given between the two parties, we were not party to it. So if the client did confirm to the contractor, yes, I'll pay you monies towards all of this, but it's not reflected in the contract, we are not party to it. And maybe that may be the reason why DIF are raising this 50%. I'm not party to that verbal discussion or mutual agreement between the two parties, so I cannot verify. I can only go by what was on site, what I saw, and what I didn't see. So if DIF can produce evidence, documentary or factual evidence to the court that they had purchased these equipment, these items, then that's something for the courts to decide and for the judge to decide. But I I didn't see anything on site, so I cannot recommend payment against anything that I did not see.
So when you refer to the 360, it's about the loose
Loose furniture. Right? That's right. Yes, loose furniture.
This is the loose furniture that has been shipped from the supplier in Greece.
Yes.
This, you said you visit the factory and you didn't mention any. The only thing you put zero value, it's because it's not installed on site.
Yes, we cannot release payment. We cannot recommend payment for anything that does not come to site. So what we did was, at the time when we did this, when we did the factory visit, the storage facility, sorry, this interior 360 storage unit visit, we took photographs, and this is all part of the witness statement. We took photographs of all the furniture that we saw, and any damages that we saw, and the color of the wood that we saw, and we shared that report, signed and stamped, and shared it with the client. And the client, and we shared it with the client's designer, who didn't want to have anything to do with it because they were not. Sure.
Ms. Abbas, can I ask you this? If the furniture had been paid for 100%, then would you, and so it was appropriated to the contract on that basis, would you accept then that you include it in the valuation?
Yes.
Yes, this was my question, in fact, but my other question is, confirm what you said, because at the end of the day, you ordered from the factory immediately after you changed the contractor, right? The same furniture that was on the warehouse.
Sorry, can you repeat that?
When you appoint the new contractor.
Yes.
You paid 360, the amount up to 100%, and you get the furniture, right?
Yes.
So the problem was not a problem of furniture, it's a problem of whether the furniture should be on the shop or on the factory. But at least the furniture were ready. My question is, the furniture were ready to install.
That's right. The furniture was ready to install. The site was not ready.
Exactly. So because it's not physically on site, the money wasn't released.
That's right. The money wasn't recommended.
It's maybe the other way around, that the supplier may not release the furniture until it's paid in full.
It's chicken and egg.
Chicken and egg, this is what I'm saying. But I mean, between the parties, I mean, because we were concerned at that time. It was a possibility to move this furniture to put on site at that time, at that stage of work. We're talking about 30%, we're talking about 40% if reached on-site work. Do you consider at that time we can move furniture on site?
No. The site was not fit to receive any furniture. The site was a demolition site with MDF and cardboard boxes on it, too much dust around it, the water fountain works backflowing, but then, and the bar counter. So there was too much work happening. It was a proper construction site. You can't get high-end furniture into a construction site and just place it there to release the money.
Okay,
but the furniture in interior 360s, the furniture in interior 360s unit was ready for delivery. It was stored for a few months, I believe, over there before. And this is from what we were told, that this furniture has been in this unit for a few months and waiting to be released. But as per site conditions, the site was nowhere fit to receive any furniture.
So you do consider this part of the work, part of on-site or off-site work?
Off-site. Furniture is always off-site. Joinery off-site. Whatever is done off-site is off-site.
Okay, so but you consider, because we did not pay these people full, we have not been delivered of the furniture at the same time?
Yes.
My second question. As of the joinery works, if I understood you well when you exposed your report now, you didn't visit the factory yourself. You based your report on Mark's video and photos, right?
Yes,
this
I
is
was
not
in.
mentioned in your report.
I was no, it's not. I couldn't find Mark's video on my WhatsApp. He had sent it to us by WhatsApp, so I couldn't find it, so I couldn't write about it. I was in contact with somebody a couple of times. I was in contact with somebody. This is just as we were coming out of COVID and stuff, and I couldn't do the factory visit that morning. So Mark went along, did the factory visit. On this project, it was both me and Mark driving the project, him from an operational standpoint, me from a project management standpoint, both representing the client. And Mark went and did the visit, and he said, don't bother coming because it's not fit for purpose. It's lying in the backyard. It's not in a controlled environment.
I agree, but you put it in your report as if it is stamped and basically scrutinized by you, and it's quite a good amount. It's around 89,000.
But if it's left in an uncontrolled environment, the risk of it deteriorating very, very quickly. Once it's delivered to site, there's a risk of it deteriorating if it's in an uncontrolled environment, especially in this country.
Sure, but this is based on Mark's allegation, right?
Yes, based on Mark's videos and videos that he took and photographs, and he said it's not fit for purpose. Don't even bother coming. They've not done it right, and there were some discrepancies.
Yes.
And I remember there were some discrepancies in the design and the dimensions, which were or weren't picked up. So that's why Mark believed that it was not the right, it wasn't the correct version of what they wanted.
But all this haven't been raised to my client at that time, and it hasn't been discussed. It looks. No,
this was informed. I think from memory they were informed of it. They knew the day that Mark was going to the factory. I think Isam may have known the day that Mark was going to the factory. They knew that we were supposed to attend. I had to drop out last minute, unfortunately, but Mark proceeded and Mark shared it with everybody. I can't 100% guarantee whether he did or he didn't, but he shared it with us. And I believe we informed DIF.
This furniture has been installed finally in the shop, the joinery works?
No, there's a separate contractor was awarded the project and they did their own joinery, and that was what was installed.
That wasn't installed?
The other contractor's joinery was installed, not DIF's joinery. That almost went to waste, both for the client and for the contractor.
Final question, it was regarding Mr. Sagaya. My question is, again, is there any attempt to reconcile the position of the two parties or not, from your end?
Sorry, I don't follow your question.
Is there any attempt from your end where you were in position to reconcile the position of the two parties?
Yes, that's the meeting I keep referring to, where both parties were blaming each other. There were heated words exchanged, and yes, that was the meeting I attempted to reconcile, to try and get them to look eye to eye and talk and move forward. And thereafter, after that heated argument, there was just it was very blatantly obvious that this is going nowhere, and the client is paying rent on the unit, making no money, no revenue generation, and they need to move forward. So therefore, the termination was issued, and a new contractor was appointed.
Yes. My last question is because my client has appointed Good Faith, Mr. Sagaya, to as external auditor to assess and to act as a mediator. It seems that nothing has happened in your end at that level.
Not with Mr. Sagaya, no.
Good Faith. And Good Faith, I mean, the company.
No, nothing.
Mentioned only one email sent to you, right?
Well, the first email.
To me, this is not material.
We never received. Mr. Sagaya seemed to drop off halfway through this whole process. He disappeared, and we didn't ever hear back from him. So we didn't think
Don't worry about Mr. Sagaya. It's not relevant. It's not relevant to the issue I have to decide. So, Mr. Bull, do you have any re-examination?
Just briefly, Your Honour. Thank you, Natasha.
Okay.
Just in relation to the furniture, it was raised that they claimed 100%, and for all but one item in which they claimed 50%. In terms of this contract and you coming in to manage this project, and at the time when you carried out your assessment, you did so based on the site work's progress. So is this the reason why we did not, the furniture wasn't...
That's a leading question.
Yes, sorry, Your Honour.
Not the only one.
Of course. To certify the payment for the furniture, what would you need to see?
We'd need to see the furniture and have it approved by the designer and the client.
And would it need to be delivered?
Yes. But in all honesty, furniture companies, the likes of Peter Bruce, BW Interiors that we work with, they all want payment upfront prior to delivery. All companies. But that happens when it's in tandem. It happens when the site is ready, when you know that the furniture can be received on site versus the furniture being ready and coming to site. So if the site's not ready, I can't accept delivery. I cannot pay 100% for furniture. I cannot recommend payment of 100% for furniture that still sits in the contractor's possession and probably never sees the light of day on site. I can't recommend something and expose the client to a risk. So although the furniture was there and we could have recommended 100%, but it puts the client at risk that what if the client had paid the 100%, and today we are sat here discussing the same matter where the site was not ready and the contractor never delivered the furniture to site. So the recommendation of payment for the furniture always happens where part payment is made, orders are placed, LPOs are placed, the furniture is done, mock-ups are done, they're inspected, and once they're told that, okay, it's ready for delivery, you assess whether, yes, please hold on to it for a week, 2 weeks, 3 weeks, 4 weeks, or put it in storage, hold on to it. We will only release the remaining balance payment, full balance payment, once we're ready to receive it to site. And if the site's not ready, you can't receive it.
Thank you, Natasha. Thank you. Thank you, Your Honour.
Thank you, Ms. Abbas, for your evidence. We're extremely grateful for it. And you are released to do whatever you want to do. Thank you very much indeed.
Thank you. Thank you all. Thank you, Judge. Thank you.
Good
Bye-bye.
evening.
Good evening. Bye-bye.
Bye-bye. Okay, that is that for today. Then tomorrow, well, we've already had Mr. Fadali's evidence, so we have Mr. Khatib and Mr. Sagaya. So we are going to start again at 10 o'clock. They shouldn't take longer than an hour and a half between the two of them, I would have thought. And then I suppose you wanted an extended break to put your closing submissions together. I'm sure we can deal with that. So what we might do actually is take that evidence in the morning and then come back in the afternoon, maybe at 1:30 or 2 o'clock. We'll decide which is more convenient. Okay?
What time we start tomorrow?
10 o'clock.
10.
Yes. And so Mr. Khatib and Mr. Sagaya must be available at 10 tomorrow.
Mr. Malik, Your Honor, will be on video call online.
Mr. Khatib will be on video, okay?
Yes.
Well, that's fine. Well, then we'll have him on video at 10 o'clock.
We have to move it to 10.
Yes, we have him at 10, and then Mr. Sagaya will be after that. Because if we put Mr. Sagaya live first and then he goes on longer, then he'll be waiting around. So it's best to have the video evidence first, like we had this afternoon. Sorry, I mean like waiting around that we had this afternoon. Okay, so 10 o'clock tomorrow. Thank you very much indeed.
All rise.